the way, Manoj, with
1
respect,
minute,
he
please.
intervened because
Allow
I
me
had
to
not.
show I am doing something which will be in your favor. I will, Lord, not sell the property. That's what I'm saying.
That's all. That's all that we are saying. You cannot argue why is that an argument?
I want your Lordship to record that, Lord, I have mortgaged the property. I will not, Lord, transfer or alienate the property without the leave of the court, and their main petition may be heard, in which they will re-urge, Lord, the question of fraud. That is the legal procedure.
That's all we are saying, Manoj. That's all we are saying for the time being.
That's okay. Then I'm saying something in your favor. What's the problem?
1 minute. I wanted this court to decide.
1 minute. Yes, Dr. Singhvi, what is your response?
I wanted your Lordship to decide, but I think it's a fair suggestion. We don't want your Lordship to waste time. Let it be decided by the High Court with a clear recorder that it will not be.
Not the High Court. It is to be decided by DRT.
DRT. I'm sorry. DRT.
Right.
DRAT.
Not DRT.
No, DRT.
It has to be decided.
Securitization is in DRT, my lord.
There is a Section 17 application.
Yes.
High Court has granted liberty
DRT.
to borrower to amend the Section 17 application. After the Section 17 application is amended, the DRT will hear the parties and decide the matter. Till such time, the DRT decides the matter. We will record Mr. Rodgi's undertaking that he will not alienate, encumber, or dispose of the property without obtaining the leave of the DRT.
Yes, correct.
Obliged.
And Milord, one more
May I
thing.
just make one submission?
One more thing. They have already, Milord, made an application for amendment pursuant to the impugned order, which was, Milord, yesterday.
Decided together, Manoj. They have decided together.
Very well.
Manoj,
Mr. Gopal, you wanted to submit something?
One small submission. Mr. Rodgi's client has mortgaged this property to the Punjab National Bank. The Punjab National Bank sought intervention in the High Court, saying that, look, we had no knowledge that there was this dispute pending and there was an order of the tribunals below. The problem is that now Mr. Rodgi can make whatever submission he wants. But since Punjab National Bank is not here before your lordships, making a similar statement, the difficulty is, would Punjab National Bank be in any way bound by this? Because as the mortgagee, they are entitled to take whatever steps is necessary. The reason why I am effectively...
It's a hypothetical situation. Mortgage was 2 years ago.
Gopal, one thing.
Yes.
One thing, Mr. Rodgi has mortgaged the property.
Yes.
We will record that in the event Mr. Rodgi's client defaults in making payment of the installments,
Yes.
it shall be open to the Punjab National Bank to obtain the leave of the DRT and
Absolutely. Absolutely. No problem. No problem. And I will not let go of this property, my lord, just for default of the bank. I took a loan to purchase the property. I will not let it go like this.
Just the other point is only this, Mullah.
Learned Senior Counsel for the in 36.1, naam de dijiyega. Mr. Gopal Shankar Narayan, Learned Senior Counsel for the petitioner in 36, and Mr. Mukul Rodgi, Learned Senior Counsel for the auction purchaser, within bracket. What is your name, Mr. Rodgi?
Yes. Milord, the name is Juana R2, Milord, Juana Sanjeev, Mrs. Juana Sanjeev Uppal.
Very well. Mrs. Joanna Sanjeev Uppal.
My lord.
R2. Right. The High Court of Bombay, by the judgment order, has set aside concurrent findings recorded by the Debt Recovery Tribunal, so and so, and Debt Recovery Appellate Tribunal, so and so, whereby sale certificate issued in favor of Mrs. Joanna was set aside on the ground of fraud. While holding so, the High Court has granted liberty to the borrower and the landowner, represented by Dr. Singhvi and Mr. Shankar Narayan respectively, to amend the pending application before the DRT so and so under Section 17 of the Surfacing Act. All points have been kept open for the DRT. to decide. Insofar as the sale is concerned, we do not find any specific observation having been made by the High Court. And it is this aspect that needs to be dealt with.
So, sorry, my lord, sorry for the interruption.
Yes, sir.
The High Court has set aside the orders of courts below, which had set aside the sale. So the High Court's order.
The sale revives.
Yes, sale revives.
And that is
And
what the High
therefore,
Court
my lord,
should have addressed. It should have said something about this, that either the sale will abide by the result of the DRT.
That's correct. That's correct.
That you will not alienate or encumber.
That's the problem.
Lord, it has said in para 30. It has said in para 30, my lord, then all questions are left open. It goes back.
No, that's not the point.
When the sale certificate is set aside by the DRAT,
My lord.
DRAT's order is set aside by the High Court,
Yes, my lord.
sale certificate would revive.
Yes, my lord.
So where is the observation with regard to the sale certificate which now revives? You are not under any condition.
That's
You can
there is no condition.
You
No
can.
condition.
That is why his statement is vital. His statement
That
is
is
vital.
why we are saying this, sir. We are conscious that this is the limited point where the High Court should have made some
All
observation.
right, your lordship may send it
This
back.
will not
We
affect
will
your
re-argue
interest
it, no problem.
as you have submitted.
As your lordship pleases.
Right. We record the submission of Mr. Rodgi to the effect that Mrs. Joanna has mortgaged the property with Punjab National Bank and that he intends to pay the installments on time. We also record Mr. Rodgi's submission till such time the DRT proceeds to decide the Section 17 application on merits de novo in terms of the order passed by the High Court. Mrs. Joanna shall not encumber, alienate, or dispose of the property without obtaining the leave of the DRT. It is also killing the liberty granted by the High Court, the borrower and the landowner have filed applications for amendment which are pending consideration before the DRT. This is correct narration of
That's
facts?
correct, my lord.
Yes. I just want to clarify, in fairness, I, the landowner, have not filed. Mr. Singhvi, Dr.
The
Singhvi's
borrower
client has filed.
not landowner.
Yes.
Only the borrower has filed application for amendment of the
It's
section.
only his essay, my lords. No other essay.
Having
We are seeking
the aforesaid
improvement in his essay.
conditions and circumstances, we dispose of these special leave petitions, granting liberty to the DRT to consider the application for amendment of the Section 17 application filed by the borrower in accordance with law. The DRT shall thereafter be at liberty to decide the issue finally upon granting adequate opportunity of hearing to
That's
all
right.
the parties, including the secured creditor, which, in this case is Union Bank of.
And the landowner.
Till such time, the DRT decides the Section 17 application, the undertaking given by Mr. Rodgi on behalf of Mrs. Joanna shall remain operative.
Grateful.
Stop. It is also made clear that should Mrs. Joanna fail to pay the installments on time and the Punjab National Bank wishes to proceed against Mrs. Joanna, it shall be under an obligation to obtain the leave of the DRT.
Grateful.
We reiterate that all points on merits are left open for the parties to urge before the DRT for a reasoned decision by them.
Grateful.
Deeply obliged.
Grateful.
Yes, my lord, I am appearing on behalf of the petitioner.
The appeal has been
My lord,
dismissed.
here,
Co-accused appeal against the same order has been dismissed, madam. So,
my lord, he has served more than 15 years
So that.
In person, and identification is, my lord, only one thing. Identifications through TIP, which is vitiated, my lord. Kindly see page 70.
Said to be behind bars for more than 15 years, then that template order. $38.
Miller, I appear for a petition in this matter, Miller.
Yes.
But this is a 138 proceedings.
Sir, you have been let off leniently. Huh?
Miller,
Check is of 15 lakh plus and fine is
yes,
only
Miller.
15 lakh plus. Do you want
Miller,
us
what has happened is,
as to why
Miller,
you should not be
he
sent
claims,
to
Miller,
prison?
that
You want notice to be issued as to why you should not be sent to prison apart from fine? Sorry.
Miller, I wouldn't want that. Miller.
Dismissed.
Grateful.
May I please?
39.
Lord, I am appearing in 39.
Yes.
Yes, Lord.
Yes,
Lord,
Mr. Singhvi, para 14.
Yes, Lord. Para 14.
Reasons
Yes,
are
Lord.
given.
My Lord, 44 lakhs is my annual return. And the income assessed is 25 lakhs a month, which translates to 3 crores as opposed to 44 lakhs. And my Lord, this is on the basis that we are a family of Aligarh. I am having a big house in Aligarh, not in Delhi or in a metro, my Lord. And my Lord, we had 4 children. This marriage is of 23 years and 26 years. And 4 children, out of whom 3 I am bringing up. The 4th child is with the mother. He's a major. And my Lord, this is highly excessive. I am spending a lot of money in bringing up my children. They are studying. My Lord, 3 crores plus a car.
Maintenance, Mr. Singhvi. Three concurrent findings are
Yes,
there.
sir.
Why should we interfere?
My Lord, this is really an assessment.
Get it trashed out before the trial magistrate.
Pardon, my Lord?
Stage.
My Lord, kindly see.
Not stage, not at this stage.
My Lord, just because I am bringing up my children in a good way, they are studying abroad, therefore to assume that, in fact, that should be a factor in my favor.
There are
How do I
concurrent
shell out so much
findings
money,
of
my Lord?
act leading to award of interim maintenance to the respondent by 3 courts. In such view of the matter, we are not inclined to interfere at this stage, leaving all points open for the petitioner to argue before the trial magistrate, especially if petition stands dismissed.
Great.
Yes. Item number 40.
Whereas I am appearing for the petitioner matters. Whereas I am protected by Honorable High Court of Gujarat from all causative method matters. And I appeared before the investigation agency, this is point number 2.
Proceedings are pending before the Gujarat High Court. Why do you come with the 32 petitions?
On 16th of April 2026, after no cause action protected by the Honorable High Court, they have freezed my 6 bank account
For the High Court, sir.
additional bank account, my lords.
Freezing of accounts, we will entertain a 32. Sorry. Dismissed with liberty to approach the jurisdiction of High Court.
Withdrawing it, my lords. I am withdrawing it, my lords.
Very well. Dismissed as withdrawn. Forty-one last day also nobody appeared. Huh? 41, anybody? Or a second call maker. नहीं आएगा. Pass over.
My lords, 42 is also a foreigners tribunal matter.
Foreigner tribunal 42. 43 adjourned as per letter.
44.
44.
Total 44, my lord. Mr. Vikas Ranjan Bhattacharya leads us, my lord.
Yes.
And I am with him, my lord. I'll make the second submission. There are I think 4-5 matters.
We are for the respondents.
Main matter is
We are for the respondents, my lord.
We are for the, we also for the caveator.
caveators.
I appear for the.
We are for the caveators.
Mr. Gupta.
I appear in point 1, my lords, for the petitioner.
Argue for the petitioner.
I'm sorry, my lords, I can't.
Very short plan that the Honorable Court did not really go by the principles of Article 14 and 16 when there is a basic allegation of institutional fraud. The learned judge records anyway, the appointees are not responsible, but that cannot be a ground to uphold the appointments which are made absolutely in violation of law. And on basis of the money, there has been a CBI investigation. CBI investigation noted huge crores of money were exchanged for the purpose of this appointment. Now, this requires consideration by this Honorable Court.
Lord, actually, we have been working for 9.5 years now. There are no allegations against any individual.
Patwalia, we are not passing any interim order at this stage. But today, if the allegation is this, that the candidates who have been appointed, they do not possess essential qualifications. What will be the
Well, it is
effect
not
of
the
it?
allegation.
What is
There is no such
No, I correct.
This is pertaining to appointment of primary teachers.
Correct.
2016, the process was initiated. We would like to know, after the primary education board is served with notice, how many of the selected teachers had TET?
Yes.
At least we had.
All of them.
Beyond
We are all qualified. We are all teachers.
Let the records be produced. It will be.
Kindly see the advertisement first.
We are all if I can just respond.
Mr. Bandopadhyay, if the advertisement does not say about TET qualification, that does not take away the rigors of section 26.
We all have TET, madam.
We have
all
of them, they have
All of you have it, then well and good.
It is not, we have all expert ballot after participating in the only point which was agitated.
You are not touching your appointment right now.
Till
You are not touching your appointment right now. You continue.
It has been said that Malad,
after 5 years from the expiry
CBI
of
has
time.
segregated Malad. It is not like the SSC matter where the CBI couldn't segregate.
Kindly come to page 308.
Anybody, today, if anybody is found 5 days prior to his superannuation that he did not have the essential qualification, do you mean to say that the employer has no right to terminate himself?
All of us have Malad. That's the essential qualification.
One submission.
Can I request kindly come to page 308?
One submission.
Mr. Bandopadhyay and other learned senior counsel, can you have any right of audience at the stage of issuing of notice?
No.
I only have a suggestion. That is all right.
If you don't have a right of audience, please bear with us. To come with your counters, we will consider. We have not issued any order of stay. If we were to issue an order of stay under 148 capital A, you definitely have a right.
Only one request. Your Lordship is making one observation. Which I am.
Your Lordship is not
Observation is not
Our
correct.
endeavor is to find out that our children are taught by people who are duly qualified.
Certainly.
Your Lordship is not
We do not have any objection there. So what?
No, certainly not.
If we endeavor to find out whether the teachers whose appointments were cancelled, whether they had the basic qualifications or not, we will not stand in the way.
Can I suggest? That's the reason I am requesting your Lordship kindly
An early returnable date.
Yes,
Lord,
that is
I-
the
My lord,
problem.
may I make
And
one
early
submission, my lord?
returnable date.
Consider early or later
Can
on,
we
it will come
submission?
after the partial working days. It cannot come.
All right,
inside
my
the-
lord.
in July or
Please, my
August, your
lord.
lordship may keep
Lord,
it.
Lord,
I-
It will come.
Let them
I
accept
want
the
to
notice,
say
my lord,
something,
and formalities be waived.
My lord,
Whoever
can I
is
make
on
a short
caveat,
submission?
service need not be affected, dispensed with.
That's right.
But service,
Lord, I also
database
appear on
people,
caveat.
service on the primary education board,
Must
and
be
whoever
okay.
is in public
We are
officials,
here, my lord.
they have to be served. Mr.
Primary
Gupta, you are
Education
appearing?
Board is here, my lord. We'll accept, sir.
Acha, for
Mr.
whom,
Gupta is
Gupta?
here. The
My lord, your
primary
lordship put a
education board, I
question, my lord.
believe.
Your lordship put a question. They are all TET trained, my lord. That is not a problem, my lord. Your lordship wishes
Very
to
well,
clear the
we'll
matter, we will
consider
file.
that. First, you have to satisfy yourselves.
Yes, your lordship, just one
All
other,
we are
one other point of
all we are
notice. We are all
trained rather than
caveators
petitioners
who are
are
appellants
untrained.
before the High Court,
We
but
can
our
well imagine that if we have to encounter this at the notice stage, what will happen after the final hearing?
Yes.
I only had a suggestion.
Maybe your lordship's
become
on
easier
the
because
party.
we have all the
Let
qualifications
the
to basis
records
on
be
affidavit. No
disclosed.
difficulty.
Records be
Petition was
disclosed.
not maintainable.
Everything.
13,000 teachers without being heard.
You are only running after
terminated.
Lordships, we are caveators who are appellants before
And
the
my
High
lord,
Court.
kindly, my lord, once
Your Lordships,
these
we are
paragraph
caveators who are
190
appellants
where the
before the
CBI
High
has
Court,
said that
but
we
the
are not
appeal
the
has not
group
been
of
filed in
parties.
our matter.
purchasing
Out of
job
44
by
appeal,
money.
appeal has been filed in one case. We are all appellants before the High Court.
But
We are all appellants
I
before
think
High
once
Court.
your
Lordships,
lordship
you may be
issued
heard.
notice, we'll come back in July, my lord. I don't think this is really
In
necessary
better
today.
times.
Yes, yes, my lord, we will file in July. Your lordships will hear us in July.
Very well.
Yes.
For the caveat,
By-
for the objection, even
by-
us.
But the opening statements which were made, the impression which was given to the court was totally wrong.
Released in the third week of August.
My lord, deeply.
Third week.
August.
I mean, we may also be allowed to file counters, my lord.
Everyone.
Caveators?
We are
Caveators?
allowing everyone to file counter, whoever is served or whoever is appearing on caveat. Yes.
My
next.
lord, my lord.
45.
45, I beg to appear for.
Madam, is there no intra-court appeal available before the Allahabad High Court?
My lords, there is, my
Item
lords.
45.
There is, my lords, I am
Then
sorry.
why have you come directly?
I am sorry, my lords, I did not even notice this. Would your lordships record my statement?
I'll
and
tell
permit
you
me
why.
to-
The limitation is 60 days. 60 days. And you have already crossed 600 days. So you thought, let us take a chance before
My
this.
lords, I apologize. Your lordships may record my statement and permit me to go back, my
All
lords. I
right.
apologize.
Madam seeks leave to withdraw this special leave petition with liberty to file an inter-court appeal before the High Court. Permission granted. Liberty as paid.
I'm grateful. my lords.
Forty-six.
Minutes. May I seek a password, minutes? Please, minutes.
Passover. Yes.
Minutes.
Passover 46.
So I appear for the petitioners in 47. This is the Axis Bank regarding the deposit of large amounts of money.
But
During
Gopal,
the
you will have to
demonetization.
deposit the money with the registry.
Manoj, I'm the petitioner. I had to accept the money from the person who was depositing it.
Right. So you are now the petitioner appellant before us.
Yes, but that money has never been given to me. So if
Money may not be given to you,
audit will deposit
but the
it, we
direction is that you will have to refund.
Yes,
So if
But
you want a
provided-
stay of the order, we are putting you to terms.
very well.
Getting the stay order, you will have to deposit this 3 crore 19
Right.
with the registry.
Very
May
well.
I, Lordship, with your indulgence, Lordship, that we may be permitted to withdraw the amount
no,
subject
no,
to bank
no.
guarantee? No,
Not
one
at
minute, Lordship.
all.
I'm just simply saying
No.
subject to bank
Well,
guarantee.
Mr. Kohli,
No, no,
you
no.
will have to decide this matter. Your money was not accepted across the counter.
Then Lordship
How
may
can
hear
you
me
get
for a
back the
minute.
money?
Lordship may
If you
hear me
succeed,
only
you
for
will
a
get
minute.
back the money. They are keeping it in deposit.
Lordship may hear me only for a minute, only on a limited point. We never challenged demonetization. The holding is quite correct that they unilaterally prevented me from depositing. The only mechanism I had to deposit if I was KYC, I was KYC. And therefore, they create an internal policy in derogation of the RBI's directions. So therefore, Lordship, I've been denied my opportunity.
Your money will be
So it's not
saved,
about
but it will not be given to you.
The appeal is admitted. Stop. For a period of a
interest-bearing
month
FIR,
from
Lordship.
date, there shall be unconditional stay of the order under appeal. Stop. If within this period of a month, the appeal of this court, comma, of stay till the appeal. Should there be a default, comma, the order shall stand vacated and it shall be open for the respondent to have the order executed before the NCDRC by instituting appropriate proceedings. Stop. Upon the deposit being made, comma, the registry shall invest the same in a short-term interest-bearing fixed deposit account on auto-renewal basis and shall keep the account renewed until further orders to the contrary are passed by this court.
May I make one small submission?
Within 4 weeks, you joined her, 2 weeks thereafter.
Just one small submission. We'll do this. The amount which was held by them in cash, we are unaware of what has happened. RBI has sustained our position, who is our regulator, saying during the demonetization period, if you start getting trickles of cash, 20 lakhs, 12 lakhs, 99 lakhs, we accepted the first 3. The fourth one we didn't accept because we said, where is this money coming from? Give us the source.
Lordship,
They
I can
never
answer
gave us
that.
the source. That is
I can
our
insist,
stand.
Lordship.
Just
Now-
a minute.
Lordship, we were under protection of the Supreme Court because we had multiple rounds of litigation are there. There is no such thing about a trickle apparel. It was as many times, as much as you could deposit if you are KYC.
Were you at the final hearing?
Very good. Because their cash, we don't know what happened to it. It's all old notes.
Yes.
It's not about old notes. This is about deficiency of service. It's not demonetization.
48.
Grateful, Lordship.
Yes, 48. 48. Yes, solicitor.
I'm in 49, Manoj. I'm sorry.
You're in 49. Then who is in 48?
No, sir, I think you will put
My,
this
my apology, my lord. I'm in 48.
NTPC.
There is some confusion, my lord, kindly pardon me. But this is a neat question of law, interpretation of section 28 of the new Land Acquisition Act. Please have, my lord, page 26, where the provision is quoted.
26.
At page 20, it starts at page 25. Well, I might read, my lord, the whole so that your lordships, I can give the background, my lord. Determination of market value of land by collector. The collector shall adopt the following criteria in assessing.
हेडफोन से तो सुना ही नहीं।
Block कर दीजिए.
And, I'm sorry.
1 minute, 1 minute. Yes, now you can proceed.
Yes. In assessing and determining the market value of the land, namely, A, the market value, if any specified in the Indian Stamp Act, we are not concerned. Lord, B, we are concerned. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Or C, we are not concerned, whichever is higher, provided that the date for determination of the market value shall be the date on which the notification has been issued under section 11. Now please see explanation, my lords. Explanation 1. The average sale price referred to in clause B shall be determined taking into account the sale deeds or the agreements to sale registered for similar type of area in the near village or near vicinity area during, please mark this, my lord, immediately preceding 3 years of the year in which such acquisition of land is proposed to be made. My lord, proposed to be made is section 8 of the Act. That is, my lord, the proposal. And my lord, there is a purpose why, my lord, this is provided for. Lord, for which, my lord, I rely upon the standing committee report. When this act was being enacted, Lord, they have said that once a proposal is put in public domain, people start selling their lands. And therefore, that would be the right criteria to be taken into consideration. While, my lord, if your lordship permits, I can screen share, my lord, that part of the report. Only one, my lord, report is, one part is to be submitted, my lord. Your lordship, the court master may have to permit, my lord, screen sharing.
So in this case, you proposed acquisition in 2016?
Yes, but
It will be a preceding 3-year period?
yes, my lord. The section 18 is 29th April 16. Your lordships are right. So, my lord, it could have been 3 years prior.
2013?
Correct. But the court has, my lord, held that it would be from section 11 notification 3 years.
No.
That is, my lord, page 30.
Where is that finding?
Page 30, my lords.
No, paragraph 30.
No, page 30, para 22. Lord, which is contrary to, my lord, what was the intention? My lord, this was a issue which was debated, that the moment section 8 notification comes, there are transactions. Your lordship gets para 22. Can I read with your lordship? This court is of the considered view that the arguments advanced by learned ASGI appearing for NTPC Limited are devoid of any merits on account of the following reasons. On the point of taking 29th April 2016, now that is section 8, as cutoff date for computing the period of preceding 3 years to determine market value of the acquired land for payment of compensation. If the argument of NTPC Limited that the preceding 3 years for determination of market value is to be related to 29th April 26, when fresh application for initiation of land acquisition proceedings was made after proceeding lapsed under the old act, is accepted, it would lead to a situation that the 3 years prior to 29th April would be taken into consideration for determination of market value on the basis of issuance of notification under section 11, which is in the present case is 12th June 19. If such an argument is accepted, it would lead to a situation that any sale deed from 29th April 2016 till 11 June 2019 will not be taken into consideration to determine the market value as on the date of notification under section 11. Such is not the intention of the legislature. The legislature has clearly and in unequivocal words provided under section 26 itself that the date for determination of market value shall be the date. So when I am computing it, it will have to be today.
But sir,
that is section.
If you issue the 11 notification in 19,
yes,
that is the proposal for initiation of land acquisition.
No, my lord, the proposal is section 8, my lord, if your lordships can see.
एक बार law दिखाइए ना. 2013 land acquisition act.
2013. And if your lordship permits, I screen share the report of the standing committee.
Fair Compensation Act 2013.
It's a right to fair compensation and transparency in land acquisition, so and so act.
Section 8.
8, my lords. Possibly page 15 in your lordship's copy, my lord, we have the same. Examination of proposals for the land acquisition and social impact assessment report by appropriate government. The appropriate government shall ensure that, your lordships can skip. 2, the appropriate government shall examine the report of the collector, if any, and the report of the expert group, your lordships can skip. 3, the decision of the appropriate government shall be made available in local language to the panchayat, municipality, or municipal corporation as the case may be, and the offices of the district collector, subdivisional magistrate, and the tehsil shall be published in affected areas in such manner as may be prescribed and uploaded on the website of the appropriate government. Provided that where land is sought to be acquired for the purpose as specified, Lord, we are not concerned with that. That may not assist your lordship either way. Lord, kindly see.
There has been a gap of 3 years.
Yes, my lord.
If you say that proposal is in 16, section 11 notification is in 19.
Yes, ma'am.
Now, if it is more than 3 years, say, let us say 5 years, 7 years, then the entire object of this act gets frustrated.
Lord, the object we will
As the
get,
High
my
Court
lord,
has
from the
correctly held, within that gap period of 16 to 19, whatever sales take place would be rendered insignificant, inconsequential.
it can also be taken into consideration. Law provides prior to section 18, section 8. My lord, may I just read? My lord, I am unable to hand over the copy.
Proposal would be for a different purpose. This proposal would not fit in.
Lord, can I read, my lord, the report?
Such acquisition of land is proposed to be
Lord,
made.
can I circulate the report of the standing committee?
So far as the authority is concerned, who is acquiring and for whom it is being acquired. But so far as the public at large, 11 is the proposal. It cannot be antedated to proposal.
11 is not the proposal. My lord, 11, please have a look at, my lord.
Oh, 11 is a proposal in the sense, if we go back to say
Section 4, section 4.
Section 4, 5A, if I give a valid objection, your proposal does not go forward if my objection is accepted. So 4 is the proposal stage.
Lord, may I just, Lord, read? I am unable to hand over. Lord, this might need examination. I may succeed or fail.
No. In a proper case, you argue. But
Lord,
this one,
can I read? Lord, for my satisfaction, can I read?
Decimal increase.
Lord,
No, sir, not in this case. Not in this.
Can I read, my lord, the report of the standing committee?
We are not prepared to accept that 8th proposal is the proposal referred to in section 26.
Lord, can I, my lord, read for my satisfaction? It gives a direct answer.
Read it.
My lord, I am sorry, my lord, if your lordships can allow a screen sharing.
We will go by the plain words of the statute. We will not go by any committee report now.
No, my lord, this is the committee report based upon which the act was made.
Maybe, but it is an external tool.
I'll just read. My lord, please allow me to.
If the language of the statute is plain and clear, why should we adopt tools of interpretation?
May I read? My lord, your lordships may take that call, my lord, a little later. Lord, can I read?
If there is a proposal, the social impact assessment report, if it takes 2 years to come, thereafter government takes another 2 years to consider the social impact assessment report and then issues the 11 notification. Why should this sale transaction in
Lord,
between?
Section,
When people may not be knowing that it is under acquisition proposal, why should it be?
May I, my lord, unless your lordships allow me to read, maybe I'll not be able to, my lord, bring forward my point.
Please read.
May I read? On suggestion of the government of, this is, my lord, the Standing Committee of Parliament, discussing this particular bill, which become an act. On suggestion of the government of Madhya Pradesh regarding application of clause 11.4 of the bill that seeks to ban all kind of land transactions of the appropriate land before SIA is considered. That is, my lord, social impact assessment is conducted so as to, I'm sorry, my lord.
Yes, please continue.
No, your lordships would not get it in the file.
No, we are not.
It's not in it.
No, I know that it's not in the file. You said so.
SIA is conducted so as to restrain mischief mongers from artificially ballooning the prices of land. The DOLR stated that a social impact assessment needs to be conducted before notification under clause 11. However, to contain, please mark this, artificial inflation of prices, a calculation of market value in clause 26, the time of period of preceding 3 years should be taken into account from, by kindly mark, the date of SIA notification. This is what, my lord, was contemplated by the Standing Committee. My lord, kindly allow me to, my lord, place this on record. My lord, this would apply, my lord, pan India. My lord, kindly allow me the genesis, the very foundation on which the act came into force. They say that
if the authority takes 5 years for the issuance of the 11 notification, anything done in between will be rendered redundant.
Then explanation 1 will become OTOs.
No.
Explanation 1 will become OTOs.
The act should have made it clear what is meant by proposal. It cannot be just referred to section 8.
No, that your lordships will necessarily get, my submission is from the Standing Committee report.
No, sorry, sir.
No, would your lordship say question of law is kept open?
Question of law is, you want that?
Yes, my lord. In facts of this case, my lord. Because there is genuinely, my lord, it's an arguable case. Now that your lordships have dismissed, I am saying it is an arguable case, my lord.
But Mr. Solicitor, if we pass a single one-line order, that doesn't mean that the Supreme Court has upheld the order of the High Court on. It's absolutely open to you.
Not better not to leave it to other.
A single bench order. In
My lord,
some other High Court, it may have been only of a persuasive value.
my lord, better not to leave it to others to interpret your lordship's order.
We are, you know, in our judicial academy, we are deliberating on this. Let us tell you, a single judge takes enormous effort to write a judgment, 15 pages. How much time does it go behind writing a 15-page judgment? At least 2 hours in chamber. Matter comes up before a division bench. Division bench takes another 2 hours at the residential chamber to write its own judgment, affirming the single bench order. Matter comes up before the Supreme Court, and we say, not a question of law is kept open. What happens to the judicial time that is wasted there?
My lord, I may not have any answer to that. Would your lordship say in facts of the case?
So therefore, we will have to keep the question of law open only in those cases where there is doubt evidently, palpable on the face of it.
Would your lordship say in facts of the case dismissed?
This is not such a case. So one line dismissal.
I'm not insisting for.
There is no merger. There is no merger. That judgment is open. You go in a similar case and say that it doesn't mean that the Supreme Court has affirmed the judgment of the Jharkhand High Court.
Only one, but I'll not request for question of law. Would your lordship say in facts of the case?
Nothing more. We are not inclined to interfere. Dismissed.
Please, your lordship.
Yes, 61.
Item 49.
Now we are on 61. 49, perhaps post notice.
Yes, the lordship go after vacation.
I'll
tell you why not. This is that matter regarding that MSME. The latest RBI circular has to be shown to your lordship. That's why. I don't know when your lordship will take it up. Or shall I wait?
If you are not available, we will keep it after vacation. But
no, I'm available. I'm fully available, but I'm not waiting.
Want to finish up the fresh matters?
All right. I'll wait.
Post notice matters.
I'll wait.
Yes, item 61.
About the petitioner and the High Court dismissed the matter because to consider the allegations on me and direction to the surrender before.
Amanullah.
Yes, my lord.
Complaint case.
My lords, exactly. So, my lords, Om Prakash versus State of Jharkhand, my lordships, as early as April of this year, has clarified that in complaint cases, the summons has to go. It is only if the summons doesn't go that there are other processes to be followed.
He is appearing before the court. Where is the question of an apprehension of arrest?
Exactly, my lords. However, my lords, in this case, what the impugned order does is that the impugned order dismisses the anticipatory, but it also says that the SP will arrest if he doesn't surrender.
That is not proper.
My lords, is, in my respectful submission, my lords, erroneous because.
What is the citation of Justice Particular's order?
2026 SCC online SC 676.
Very well. Leave granted. The impugned judgment and order is in the teeth of the judgment and order of this court, reported in so. Accordingly, the impugned judgment and order stands set aside. We make it clear that the appellant shall appear before the trial court on each and every date fixed for trial unless exempted. Unless exemption is granted in accordance with law.
Grateful, my lords. Would my lords permit me to give my appearance in the chat box?
Before the court, no coercive steps shall be taken.
I'm grateful. My lords, could I give my appearance in the chat box, please?
Yes.
I'm so grateful.
Item 62. Yes, Madam Prakash.
My lord, it appears that a land dispute has led to institution of 3 cases. One,
Notice,
I think we've lost the connection.
notice interim 63.
My lords, it seems my lord's order is, despite my lord's order, no cognizance is being taken by the National Commission to my lord's,
Tomorrow, sir.
my lords, still my lords,
I
1
accept
crore is
notice on
there.
behalf of the state in item number 62, my lord.
Yes, 62, Mr. Council accepts notice. File your counter. Rejoinder. Come up in the 3rd week of August.
My lords have passed an order in September. Despite that, my lords, no effective steps were taken, my lords. And my lords, this is not in only in this matter, in every matter, my lords, the execution is not moving, my lords. And we are at a situation where, my lords, CC complaint takes 2 years, execution is taking 4 to 5 years now, my lords.
What can be done?
What can be done?
What can be
My lord,
done?
I think guidelines have to be followed. Rahul S. Shah, my lords, had laid down guidelines.
There are guidelines given by this court. Even then, the tribunals are not being able to abide by what? How can we say that they are not trying?
My lord, because after my lord's order, even 70 did not start the
How
section
many
proceeding.
cases are there and how many courts are functioning? All these things have to be taken into consideration.
My lord, 6 hearings after my lord's order, yet my lord, no cognizance has been taken. That is after my lord passed an order in September to conclude it by March, my lord, still no cognizance was
Fixed
taken.
before the NCDRP tomorrow. In such view of the matter, we are not inclined to.
My lord, but keep it in a time bound manner, extend it by 3 more months and say even close in 3 more months. That is, my lord, can be done.
To the petitioner to persuade the NCDRC to close the execution case as early as possible in terms of the earlier order passed by this court, as well as the order dated. Well, you have the citation of Justice Patiwala's order that all execution cases should be disposed of within 6 months.
Yeah, my lord, yes, that is Rahul S. Shah, the earlier judgment.
Just send it to the court master.
I'll send it to the court master.
Yeah.
My lords. I'll send it.
Yes. Next.
Grateful.
Item 64.
Dismiss.
Mr. Diwan, we can't hear you.
Is your lordship able to hear me?
Yes, loud and
I
clear.
can't have tea. No. This is
No, again disruption.
Where's your volume? Can your lordships hear me? Can your lordships hear me?
Yes, yes, we can hear you.
Where's your volume?
Yes,
Can your lordships hear me this time?
yes, sir, we can hear you.
Yes. So,
Yes,
Manoj,
sir.
may I just make the point? I apologize that we've been having some trouble with the.
You can use this.
No, just.
You can use this.
Again, there is a disruption. Huh?
Manoj,
There is a network issue.
I think the problem may be at my end. I apologize for that. Your lordships can now hear me?
Yes, yes, yes.
Yes. May I just state the point? This is an issue which, according to us, raises an important question of law. And the issue is really the interplay between sections 9 and 9A of the Minerals Development and Regulation Act. Now, I'll just tell your lordships what has happened. And please, may I do so with reference to the impugned communication, which is at page 577, 578. Your lordships also have the Mines and Minerals Development and Regulation Act available. We had sent it to the court master.
Yes.
Your lordships have 577, 578?
Yes, 577, we have it.
Yes. Now, this is the impugned demand which I was constrained to challenge. Now, this demand, your lordships will see, is in respect of royalty, payment of royalty, third line in the impugned communication, and also subject. Your lordship has that? Now, royalty is referable to section 9 of the Act. And section 9 mandates that the royalty would be liable on removal of the material or on consumption of the material. So until there is removal or consumption, there is no levy of royalty under Section 9. However, there can be a levy of dead rent. Just keep this concept of dead rent just separate under Section 9 capital A. Now, there is, in the facts and circumstances of our case, the removal started only after the consent to operate. There is a mining plan approval. The mining plan approval granted by the central government mandates that you cannot operate this mine until you have until all the environmental permissions are received. And in the facts and circumstances here, those environmental permission would be the consent to operate. So just keep that in view. I have, once the consent to operate was issued to me, been paying royalty. So there's no dispute on that at all. What the impugned demand does is that it seeks to impose royalty, demand royalty for a time before I had the consent to operate on a notional basis. Now that cannot be done because the statute contemplates that until such time as there is removal and consumption, you have to pay dead rent. And here your lordships may note that I have been paying dead rent throughout the requisite period, and there is no demand for dead rent. Now, may I just, we have sent it to the court master, the sections. May I just place the sections before you? So your lordships have it because there's an interpretation issue here. Section 9, first.
Why did you take the trouble of sending the entire act in a paper book? We have the enactments with us in court.
Okay, we'll keep that.
This is clear wastage of paper.
Oh, I'm so sorry. So would your lordship just take up section 9? We are concerned with 9.2.
9.2.
Your lordship has it? Royalties in respect of mining leases?
Yes.
Yes. Now I'll take you straight away to 9.2. The holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral, now mark the words, removed or consumed by him or his agent, manager, employees, contractor or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of the mineral. So your lordships have seen it has to be on the mineral removed or consumed by him. Now, in my case, the consent to operate, your lordship may just note that date, the CTO was issued in my case on 26th October 2023. 26th October 2023. And I have been paying royalty at the requisite rate from 26th October 2023. Now, what is to happen before that? So there is a provision in the statute for that as well. And your lordship will find that in section 9, capital A.
Yes.
Please take up 9A. There's a separate statutory notion of dead rent. Dead rent to be paid by the lessee. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Development Regulations Amendment Act 72, shall, notwithstanding anything contained in the instruments of lease or any other law for the time being in force, pay to the state government every year dead rent as such as may be specified for the time being in the third schedule for all the area included in the instrument of lease. Now the proviso is important. Provided that where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor or sublessee from the leased area, he shall be liable to pay, please mark the words, either such royalty or the dead rent in respect of that area, whichever is greater. Whichever is greater. So it's one or the other. Now, please have a look as to what, let me just indicate as to what the collector has done, and in our respectful submission, done erroneously. So your lordships has seen that impugned demand. It's at page 577, 578. Please have a look at that.
Is it for a period prior to the CTO?
Yes, it's for a period prior to CTO. So just have a look at it, please. Page 578.
CTO or no CTO,
Yes.
there's a payment schedule in which says that it says this minimum production requirement. It says that first year 0.
Correct.
You're not required to. You are not required to take out any mineral.
Yes.
Second year is again 0.
Yes.
And it gradually increases.
Yes.
Even if the production is 0, you are not having a CTC certificate. You are required to pay the dead rent. Because when the
correct.
production
So
is 0, there cannot be any royalty.
No, so may I just note, your lordship is absolutely correct. Absolutely correct. So that's exactly my case. My case is dead rent liability is there, and I have paid the dead rent liability. So there is no demand for dead rent. That's exactly my case.
I am liable. Not.
The impugned demand is for royalty. That's the problem.
Was that it is prior to obtaining the CTO?
Yes, your lordship will see that from the demand itself.
Where is that?
Would your lordship like to have a look at the CTO? It's at page 486. It is dated 26th October 23.
486.
Your lordship has 26th October 23.
Yes.
So this is my consent to operate.
Yes.
So your lordship has noted the date, which is most important for our purposes, 26th October 2023.
Right.
Now, please see the impugned demand at page 578. He's starting the impugned demand from 1st April 22. I'll explain to you how. 22-23, and then 23-24, and then 24-25. I have paid royalty on and after the CTO date. Now, how has he gone about it? So I have also paid dead rent for the earlier period, so there's no demand for dead rent.
Oh.
Now, the High Court has confused itself and said, followed a precedent of dead rent for the purposes of royalty when the concepts are statutorily completely distinct. Now, please have a look, if your lordships would, as to how the collector has proceeded. This is on the basis of page 309, which is the erroneous basis.
Yes.
May I, with your permission, before I take you to that, just show you 107, please, and then I'll take you to 309 right away. Just go to 107. 107, annex your P5. Now, this document at 107, 27th November 2019, is what allows me to proceed because it's my approval of the mining plan for my mine. Please notice this. Subject, this is from the central government. Approval of mining plan submitted by you for grant of mining lease for so-and-so limestone deposit.
Please wait, please wait.
Yes, certainly.
Then senior counsel appearing for the petitioner submits that the impugned demand notice dated 17th March 2026 claims royalty from the petitioner for a period prior to obtaining the consent to operate into bracket obtained on 26th October 2023. According to him, in terms of the provisions of Section 9, royalty can be demanded only if the mining leaseholder removes or consumes minerals, which did not happen prior to the consent to operate was issued. We record Mr. Diwan's statement that the petitioner had been paying the dead rent till such time the consent to operate was issued. He should notice stay of the demand.
I'm grateful.
Yes, please.
Wait, please, my lords. I'm appearing for the petitioner in item number 65, my lords. Now, in this case, my lords, the order of the registration of FIR, my lords, it culminated vide the order of the learned judicial magistrate, my lord. Now, the investigation was at a nascent stage, wherein specific allegations for inducement of the complainant was made against all the accused persons, my lords. At the threshold, my lords, unfortunately, my lord, the entire FIR is quashed.
Because arbitration clause in the LLP agreement?
Yes, my lord. Arbitration clause was there, but despite the arbitration clause, my lords, there was specific instances of my lords criminality involved in that. And
You are giving a criminal color to a civil dispute.
No, my lords, may kindly see the specific allegations.
Very exhaustive. Let it be.
Lords, my contention, my lords, even the learned, the investigating officer has found instances of forgery in that.
Let it be, you please.
66.
I'm appearing for the respondent.
When?
After 2 weeks notices
Why after 2 weeks?
This has been adjourned fourth time adjournment has been taken, but if it can
Last and final, after vacation,
this can be heard this side of the
We
vacation.
keep it on
That's
next
all I'm
Friday.
requesting.
Very
well,
well. After vacation.
Very well, Monday.
Very well.
Next.
Yes.
Monday as last opportunity. Yes, 67.
Wait, please, your lordship. Lord, your lordship had come up on the last day when your lordship was noticing that one SLP had been dismissed against the same judgment.
Yes.
Now, and then when I said it was different, your lordship said your lordship had not seen it. Now, the point here is we have already been appointed as assistant teachers from March 22 to April 23. The only impediment in our appointment at that time, we are B.Ed qualified. At that time, the only impediment was the state rule said we must have 50% at graduation before getting admitted to B.Ed. That NCT clarified in 2019 saying that for those who have done B.Ed prior to 1st January 2011, that 50% in graduation will not apply. There are 3 judgments, 2 of the High Courts, 1 of your lordships. When they did not allow us to compete, we went to the High Court. High Court said, yes, I'll read that interim order, that these people have done it from before 11. They have to be allowed to compete. We were allowed to compete. We got appointed. And we have been continuing since then. Thereafter, my lord, comes Divesh Kumar's judgment on 11th August 2023, after all of us had been appointed, which said B.Ed is not a valid qualification for those who are yet to be appointed after our judgment. I will read that clarification application to your lordships. Now, the SLP which came earlier are those people who had not been appointed. And they said against the remaining vacancies, please appoint us also. Your lordship said, no, we are not going to entertain. So far as I am concerned, my High Court has not decided my controversy. High Court says because Divesh Kumar has come, your writ is dismissed. I filed a review saying Divesh Kumar has nothing to do with me. That was not my controversy. My controversy was whether I have 50% is required or not. That your lordships have decided. I am continuing now for the last 4 years. If your lordship,
What about this Kuldeep Dabral versus State of Uttarakhand?
that is the one which I am explaining. That is the one they were not appointed. They came against subsequent vacancies. We have passed on that entire SLP paper book to your lordship's moderator just now. They were never appointed. They have nothing to do with us. We have been working for the last 4 years. Now the High Court has not decided our matter at all.
Learned Senior Counsel submits that persons who had not been appointed had unsuccessfully challenged the common impugned judgment and order before this court, resulting in dismissal on so-and-so date, whereas the petitioners have been working for substantial period of
March 22 to April 23, we have been appointed.
March 22 to
April 2023. On different dates we have been appointed.
Till 2023, and therefore are not covered by the opposite order of this court. Issue notice, if the petitioners are in service, their service may not be disturbed without.
Your lordship, what they have done after the High Court judgment now, they have passed these termination orders and issued them on, I'll just tell your lordships. Your lordship may kindly stay, allow us to stay our termination.
No.
2nd May 2020.
Mr. Patwalia, termination can never be stayed. Termination.
Then whatever order your lordship was saying, if we are in, we will take that.
There is a judgment, not a judgment, was short order Sumandat versus State of Haryana.
About 30 of us have been relieved, rest are working, my lord.
If anybody is working, he will be protected, but not those who have been terminated.
All right. We will come back, my lord. Let us.
It's only at the instance of one petitioner. Or how many are there?
No, there are about 50 of them, 50 of them, my lord, in different matters. 50.
Yes, next 68.
Your lordship, please.
How much time
I
do you
requested the court master to hand over a small note.
How much time do you require?
We require, in the application, I said we require at least 2 months' time. Will lordship just look into the note for a minute so that I will be able to explain? Kindly look into the note, small note which I.
Very well, you'll get 2 months' time.
Very well, sir, very well. I also want to, in fact, just to inform your lordship, I also want to find out if I can, because it seems to be too complex a matter. And then your lord, just Satish Sharma told me there's only about 25, 30, but we found out there were 2,500 applications only in civil lines. So we want to look into
that is why 2 months time. That is why 2 months time.
No. I only want to say that I would like to take stock of and find out if I can have a solution to the problem.
That also you do it, and you are. I'm very hopeful you will find a solution for that.
Maybe it's important lords can make an observation that having a regard to the time required, if it's possible, a solution I can push the government into thinking.
My lords, one humble submission which is very important for the city of Allahabad. My lords were pleased to order for the tabulation for 96 to 98. My lords, that will not be able to give the right situation of what exactly at the threshold or at Allahabad has happened. So, my lords, may kindly consider making it till 2006, my lords. Or because the things have been done after 98 on a very higher scale.
Then it will be a gargantuan scale that nobody can manage it.
Government policy of 92 and 98.
That's right.
So we cannot make it 2006 if there is no government.
May lords, till 2004, may kindly consider may lords.
No. If the policy is not there.
2004 policy. This is built 92 and 98. Referring to the order dated 21st April 2026, learned Mr. Venkatramani, Learned Attorney General for India, seeks and is granted until 31st July to complete the exercise of submitting the status report before this court as directed. Since we are granting sufficient time, it would be desirable if the state of Uttar Pradesh in the status report to be filed indicates an acceptable solution that would lead to putting an end to the lease.
Your lordship, please.
Released before this bench on 12th August at 3:30 p.m.
Very good. Very good. Grateful. Great.
Application stands disposed of. Item 70. Yes, item 70.
Note 70, I'd like to appear for the petitioner, Manoj. Manoj, this is a matter where the judgment was closed. Matter was reserved form.
What is this?
It's only clarification.
No, it's not clarificatory, Manoj. Let me just have the SLP just for a moment. Let me just have the application for amendment at page 99 and 100.
Very sorry. Very sorry.
There are three aspects. There are three aspects which are being amended, Manoj.
Let the matter be decided.
There is a prayer which is being added after judgment is closed. 3 dates, Manoj, the judgment is closed, and then thereafter they file the application for amendment.
We allow
3 dates,
in
Manoj.
the pleadings at the Supreme Court level.
Let me just have page 93. Just for a moment, Manoj, page 93.
Cross the tribunals at the sorry.
There is a new prayer being added. They are recouching the entire application now. And on top of that, they are rescinding their admission that they have made before in their appeal.
Next matter. Sorry. Next matter.
Grateful.
PC Act.
May it please, my lords. Was my application for regular bail for the now in custody. There is no sanction as of date. There is no cognizance for the last 3 months on the charge sheet that has been filed. But I'm sorry, I couldn't hear, my lords, your lordships.
Better you don't hear it.
Dismissed.
All right. Can I renew it, my lords, after then?
No, sir. My brother has issued notice.
Normally, your lordships, they don't joke, so I was taken aback, my lords. Normally, my lords. Normally. I'm obliged, my lords.
Thought for a moment that we had heard by issuing notice because Mr. Dave himself was not too confident.
I'm sorry.
Taking time.
But no sanction is there.
Yes, my lord. I'm obliged, my lord. Grateful to you.
41.
Please, my lords. My lords, I apologize. I did not appear earlier. Actually, my lords, in this case, I had issued an NOC to the client in 2024 itself. Somehow the client has not engaged another advocate. There were 2 cases.
Let it go. Certified copy has not yet been applied even now. And this 1116 days delay refiling delay is not attributable to the advocate on record. So therefore, let it go as dismissed as time barred.
Please, my lords. Obliged, my lords. Again, I apologize, my lords. I was not aware this was listed.
So 46.
Lord, appear for the petitioner. Lord, this is the same matter, Lord, where the order was not uploaded. Last week we had appeared. Lord, for 2 months the order was not uploaded. The order is of March 2026 and uploaded only on in May 2026, my lord.
Right.
Lord, the issue in this matter is whether, my lord, when does the
Chitnis, please see para 14. It has been held in the facts and circumstances.
Yes, my lord. But if your lordship sees, my lord, para 14, my lord, the learned judge says that the time to take steps, my lord, limited. If your lordship sees the middle of the page.
Why should a litigant suffer if the DRT issues the recovery certificate late?
Lord, but that was the earlier provision was like that, Lord. I had a benefit of that. The recovery certificate issued much later, my lord. So that when there's a debt become due, my lord, whether it's conclusive, my lord, it became conclusive on the first date only when the matter was adjudicated. Therefore, my lord, time should run from that date. Lord, that issue is pending for this honorable court, my lord. Lord, whether the time became time started to run the first date or on the date of the recovery certificate, my lord. So, my lord, my submission is that it should run from the adjudication, my lord.
Rendered its opinion in view of the
Lord, may I just make a submission, Lord, that we are ready to pay the money, Lord, some indulgence.
We keep the question of law open as to whether the Limitation Act or the schedule forming part of the Income Tax Act would apply in a case where
We have
the
made a
question
proposal, my lord.
in relation to the period of limitation
It's a dwelling house, my lord. I'm ready to make payment, my lord. Some indulgence.
towards a debt which has been adjudicated by the DRT.
No, the loophole was closed after the amendment.
Longer survives. Certificate has been issued, now you will have to fight it.
My lord, I wanted to make payment, my lord, but now, my lord, if there was some indulgence, then I would have made some payment, my lord.
Wanted to make payment, you would have made it long before and not drag the matter to the High Court. Sorry.
Obliged, my lord.
Dismissed. Dismissed. Next. Item 60 brother ये ऑर्डर किया है.
Item number.
We are
Item numbers.
the appeal
Yes.
by directing release of the vehicle bearing MP 06HC1353 on such terms as the district magistrate may deem fit. However, we are making an observation that since the High Court is presently seized of the appeal against the conviction,
Yes.
the petitioner shall be barred from disowning the vehicle in question in course of consideration of such appeal.
My lord, we will not decide. My lord, only thing is that if your lordships would kindly make it time bound so far as the release is concerned, because it is lying in the police station for the last many months, my lord.
Many years.
Many years rather. So it would have become a junk by now, I think.
Then why are you asking for it? You are digging your own grave, Mr. Mukherjee, by claiming ownership of the vehicle. Anyway.
No, ownership was determined when I was convicted.
Within 2 months.
Much obliged.
Within 2 months.
Within 2 months.
Much obliged.
Yes, now next. Mr. Datta paid for time after.
Yes. Lord, can be taken because I want to show some letters. Lord, your lordship's judgment, there are conflicting.
Not today.
Not today. Yes.
After having it on another day.
After the partial working is over.
I see.
Because now we want to revive, the government has changed the policy and place those documents after
August.
Grateful.
August. Can it be second week of July, my lord, if it's possible?
July
August.
1st.
August.
Miscellaneous, Mr. Datta.
Okay, August.
We don't have much time. So August it will come.
Grateful.
Lordship, may give a date.
Lord, that interim.
4th August, if it can be on 4th August, if it's possible.
Let us see. The court master will find out,
All right. Deeply.
ROP will find it.
My lord, interim order to continue in this.
Very well, interim order to continue.
Obliged.
Item 50.
My lord, I got the counter affidavit today only in this matter, my lord.
Rejoinder 2 weeks.
I would file the rejoinder within a week, my lord. I request that if the matter is listed before vacation, my lord, because the Haryana matter has already been taken up in the Rajneesh Kumar.
My lord, if I may interject, my lord, for a moment here, my lord. My lord, his limited grievance before this honorable court was, my lord, that the letter which has been given to the Honorable High Court by way of which the advertisement was withdrawn was not provided, my lord.
No, this is
Now,
not the only grievance. This is not true.
Allow me, my friend. I'm not yet finished. Just give me a minute. So, my lords are aware, my lord, there is a main matter which is coming up tomorrow, wherein those directions were issued, my lord, with regard to appointment of these positions across India, my lord. Tomorrow, my lord, it is coming as item 43. Nonetheless, my lord, his grievance before the High Court was, my lord, with regard to withdrawal of advertisement, since they applied and they appeared and written examination, etc., was done, my lord. Lord, my request would be, my lord, either may, my lord, permit him, my lord, to go back to the High Court Now, my lord, that letter is also there on record. My lord, it is annexure R3, whereby, my lord, this advertisement was withdrawn for administrative reasons, my lord. If still, my lord, my lords want to hear it, my lord, I'll assist it as and when convenient. my lord.
Hear you, and tomorrow the special educator matter will not be taken up. Tomorrow I'm sitting with Justice Masi for disposing of the parted matters.
Very
So
well.
we'll stand over.
Very well.
Special educator will stand over one week for rejoinder. The list, are you available in the first week of June?
Yes, my lord, I am.
Mr. Sangwan?
My lord, if my lords may permit me virtually, my lord, I'll assist the court, my lord.
Acha, okay.
But my kids are
So-
studying in US, so
first
I'm
week of
supposed to
June.
join them.
Obliged, my lord. Obliged.
June.
Very well.
If the lordship may allow, may I mention the item number 1 Passover matter?
Please wait, please wait. Please wait.
Item?
51. We call it 50.
I appear for the statement.
Oh, there is that matter.
Yes, Lord. It
Yes,
is.
my lord.
Though the complainant is yet to enter appearance, but I filed an affidavit, my lord, which he has sworn to and attested. And I handed over, my lord, if your lordships kindly have a look at IA 154175 of 26. And at page 8 of that,
Yes.
my lord, at page 8 of that affidavit, the complainant, my lord, who's R3, he says, my lord, in para 3, that I have resolved all my grievances with all the accused persons, including the petitioner in the present case. I do not wish to press the present complaint, FAR, any further, or any other proceedings in future against any accused persons arrayed in the present FAR. Therefore, the present FAR may kindly be quashed so as to close the present case. That I am swearing this present affidavit without any fear or undue influence, and the present affidavit may kindly be treated as my unequivocal and free consent for quashing the FAR. He filed a similar affidavit in the High Court, which your lordships have
Sir,
seen.
can you just tell me where it is, if you don't mind? I'm sorry, I was not able to.
Page 8 of IA number
What's it?
154175 of 26. The lordships have it.
Just give
The
me.
lordships have seen it
We
as
have
well.
it. We have it. Mr. Luthra, it is part of IA 1541.
Just give me a moment, Lord. I'll just find. Have you got it? Just show it. I'll just see. Where is that IES?
Mr. Giri, who is your advocate on record? Can he send it by mail to Mr. Luthra's
It's okay,
office?
Lord. Do we have this? I leave it to your lordship, Lord. If your lordship.
Sumesh Jha is there.
Mr.
I think it has already been served on Mr. Luthra's AUR.
Is our 142.
He's not served. It's okay, Lord. It's okay, Lord. If your lordship is satisfied, Lord, I leave it to your lordship, Lord. I've not, because I know they filed something, the High Court as per my instruction.
It's in terms of the affidavit filed before the High Court, which has already been served.
I am saying something which will not harm you. As I was saying, Lord, I understand they filed the affidavit in the High Court. To that extent, I've taken instructions.
We'll exercise the 142 and
Leave it.
who are the petitioners? We have perused the affidavit filed by the respondent number 3 complainant, forming part of IA 154175 of 2026. Paragraph 2 to 4 of the said affidavit read as follows. In view of the contents of the affidavit, we invoke our power under 142 and quash.
The number of the FAR is given at para 2 of the same affidavit.
09 of 2025, referred to above, paid the petition, accused number 3. Special petition is disposed of.
Yes. No, Lord, it's a writ petition. No?
Great for your lordships. It's an Article 32.
Yes.
Article 32, yes.
Yes.
The writ petition is disposed of. We really wanted Mr. Luthra to argue on the aspect of cooperation with the investigating officer, so that we could have used it against him when he moved an application for bail. Unfortunately, we don't get that opportunity.
Lord, I must tell your lordship, in fact, I mean, now that your lordship is saying, Lord, what has happened was, I'll give you a little background, Lord. What
what has happened is this issue in part is it's a little interesting. This issue in part not is being considered in that foundation forum for professionals brought, and in a petition by a company called Amazon Lord, and I'm the lawyer for Amazon. Matters pending in another bench.
Well, thank you.
Great. Anyway, grateful. Affidavit not. I've seen it also. There was some.
52.
May it please, Your Lordship. The counter affidavit has been filed by the state members. They accept that these two matters, two petitioners, they were not engaged in any case at which sessions triable.
Who appears for the state of Bihar?
Lord, I am tendering my sincere apology, my lord. There has been a bona fide mistake, inadvertent mistake on the part of the state, my lord. Only regarding the cases, my lord, we have mentioned in detail, if my lordship may kindly see, at page number 4, my lord.
Page 4 of which?
Of the counter affidavit which we have filed in this MA, my lord.
Counter affidavit. Page number 4. So they have antecedents.
Yes, my lord. Regarding the antecedent, my lord, my lordship have directed them to file a status report in the SLP, my lord.
But first case, Chakai PS, he has been acquitted.
Yes, my lord. We have given the detail, the entire detail regarding the current status.
Second also acquitted.
Second also acquitted.
Third also closed.
Third closed.
Closed in National Lok Adalat, my lord. And regarding the second applicant, my lord, Raju Paswan, my lord, at page number 5.
Cognizance has been taken in the first case. Second case, false. So Praveen, Deepal, and Manoj and Sanjay, these 4 were granted bail.
Yes, ma'am. Raveen, Deepal.
Now you want A2 and A6 to be treated equally.
Yes, ma'am. A2 and A6, ma'am. That's
so. What is the name of A2 and A6?
A2 is Belu Paswan, my lords. Will find it at page 12 of the application, which is my lord's order. It starts at page 10.
Belu Paswan.
Yes, ma'am.
Belu.
And 6 is Raju.
Yes, ma'am.
An application for modification in the order dated 15 December 2025, whereby the privilege of peerless bail was denied to the applicants Belu Paswan and Raju Paswan, among others, whereas 4 co-accused, within bracket Praveen, Deepal, Sanjay and Manoj, were granted the benefit of such bail. Having heard learned counsel for the parties and on perusal of the counter affidavit filed by the state of Bihar, we are of the considered opinion that Belu Paswan and Raju Paswan are entitled to claim parity with Praveen, Deepal, Sanjay and Manoj. Accordingly, in modification of the order dated so and so, we direct that they shall also be enlarged on bail in anticipation of arrest on the same terms and conditions as observed in order.
That's so good, my lord.
My lords, in item 53, I appear for the petitioner. At the outset, I would like to make a request that the parties could be sent for mediation.
I have written mediation.
My
lords, I have a preliminary objection to this. In a matrimonial proceeding, I would not ordinarily oppose mediation, but my lords, in this case, the petitioner has forged my signatures on a marriage certificate and has claimed that she is my lawfully wedded wife. Initiated DV proceedings.
May I then argue my matter, my lords? May I then argue?
So therefore, my lords may hear this, and I have even mentioned it because she
Here,
is.
Mr. Agarwal, we would be hearing this, but not before this side of the partial working days. So in between, why don't you explore mediation if it is?
Lordship, if I may, number 2, I have filed my application for stay, Your Lordship, of the impugned order. May I just give me 2 minutes, Your Lordship? The residence that is in question, Your Lordship, is mine. The dispute is between the husband and wife, Your Lordship. The residence is mine. And as per the impugned order, post-October, I've already arranged an alternative accommodation for the lady, Your
You're
Lordship.
going to argue, then I'll argue it, my lords. They seem to be arguing their matters.
This possesses from my own land. It's a Lordship, even if it goes for mediation, Lordship, that property belongs to me, Your Lordship. It's a dispute between the husband and wife. I don't understand as to how she's not vacating the property even after the High Court order. I've arranged for alternative accommodation. I've complied with the paper.
You say you have arranged an alternative accommodation?
Yes, Your Lordship.
The rented premises?
Yes, Your Lordship. Just 100 meters away from the current place, Your Lordship.
Answer our questions first, thereafter make submission.
Sorry.
It's a rented premises?
Yes, Your Lordship.
How much rent are you going to pay for it?
We are already paying
15,000 per month. Yes, 15,000 per month.
Not two at the same time, sir.
I'm so sorry.
You're not in court. You just try to appreciate that you're appearing virtually. If both of you speak at the same time, we can't hear any one of you. So what is the rent?
15,000, Your Lordship.
15,000?
Of the one that we have rented
Very
out, Your
well.
Lordship.
You don't have to keep that premises. Pay 30,000 to the daughter-in-law.
My lords, if
I'm sorry, Your
Lord.
Daughter-in-law, thereafter we'll consider.
My lords, there is a specific.
You don't have to allow her to stay in your house. You don't have to arrange for accommodation, but pay 30,000, we'll consider.
My lords, if I may, there are specific findings that she never resided there. We were never residing there as a couple. In fact, even in the DV proceedings, she never mentions this as ever being a shared residence. There is not a whisper of this for this property, my lords. And both the courts below have said that you may offer alternate accommodation. I offered alternate accommodation before.
If you don't want to be referred to mediation, well and good. Released after the partial working days. There shall be no stay of the order.
Lordship, just one last.
My lords had.
We are not granting any stay. Next matter.
My lords had stayed the impugned order on the last state, my lords. My lords are continuing that.
No, they say that they are now claiming.
My application.
My lords.
They have filed an application praying for stay. That is not being granted.
All right.
Not 54.
54.
My lords, a fixed date may be given in this.
Who is in 54?
Milord 54, I appear for the petitioner on 27th October 25. Mr. Banerjee, appearing for the government, had taken time to file an affidavit. 7 months have gone by, Milord, no affidavit has come. And it relates to, Milord, payment of nursing allowance to the nursing assistants. They have paid to everyone excepting 128 persons. My friend had taken last time, he said that I'll file an affidavit.
But where is Mr. Banerjee today?
Mr. Banerjee is not here today. Milord, last time also, he had taken time. Before that also, he had taken time. Milord, I'll tell you, Lordships, in brief. Pardon?
Next Monday.
This coming Monday?
Yes.
Okay. Thank you.
Please inform Mr. Banerjee.
I will do that, Milord, certainly.
Since Mr. Banerjee, learned additional solicitor, is not present, we adjourn hearing of this special petition for the day. Released on Monday next. Mr. Mukherjee, learned counsel for the petitioners, shall inform this order to Mr. Banerjee.
I will inform him. Yes.
Yes, next.
My lords, I appear for the petitioner, my lords. We are seeking short accommodation. We have recently filed a wakalatnama and there is a bereavement in the AWA's office yesterday, my lords.
Your is in bereavement, read list after.
Where for the respondents?
Partial put.
My lords, make listed on an NMD, my lords.
Let it first come after vacation, we'll consider. 56.
Please, my lords. I appear on behalf of the petitioner. The DDA has filed a counter affidavit in which they have raised an entirely new case. Your lordships
please tell me whether you were included in the list of those 120 people.
Please, my lord. Please, my lord. In three lists of the DDA. My lords, I don't know what the difficulty is. The DDA was supposed to hand over possession to me in terms of your lordship's order of the 20th of November 24, 8 weeks from then. Lords, this is after notice for the first time, my lords.
Your lordships, if I may say, I moved an application for impleadment.
Who is for DDA, sir?
I appear for DDA, my lords.
So what is your problem? His name is there in the list of 120 persons.
My lord, we have regularized. We were given the list of 9 people. No. We have given them the letter of regularization.
No, see the order passed by this court.
RCS. My lord, we had opened the premises. We had requested the RCS to conduct the draw of lots and give us the list. They have given us a list. Subsequently, we have given the letter of possession to the 9 people.
Then I really don't understand.
Can I explain, my lord? Because we are the parties who are affected by this, my lord. In fact, your lordships in the alleged final order had specifically authorized the registrar of societies to look into anyone who has an objection. And there is an yes, my lord.
Where is that order?
You'll find that at page 32. That relates to those who were excluded. I was included in the list of 120 members.
No, I can explain, my lord. Either the petitioner can argue it and then give me an opportunity to argue it.
Registrar has identified 120 members of the cooperative.
Please, my lords. I am at serial number 69, my lords, on page 81. My lords, I have page 81. I am at serial number 69.
81.
In the list of 120 members furnished by them, by the DDA, by the registrar.
You are Lokinder Verma.
That's correct, my lords.
Lokinder Verma.
There are 2 petitioners before your lordships, Lokinder Verma, and on page page 86 at serial number 109, Mr. Ajit Jairam. They were both included in the list of 120 members who were approved.
Now, please come to the learned counsel for DDA. Please come to page 31.
Yes, my lord.
Please, my lord.
So read paragraph 2.
My lord, of my affidavit?
No, the order passed by this court.
The order passed by this court on 20th November 24.
My lord, 120 members. My lord, 120. My lord, the list
please
has
read the order. You have to comply with. You have to comply with the order. Please read the order passed by this court. Paragraph 2. You don't have it.
My lord, I have it. My lord, it's just not opening up my system.
Because this was you made it.
My lord, the order contemplated, my lord.
No, please don't give your interpretation.
Must be included in the list identified by the RCS. Mr.
Can I explain it? There is a review order also on that. Page number 117 is the review order. Review filed by the present applicant.
117.
117.
117. No case for review. Review is...
And see the para 5.
Because I am not the review applicant. I don't know who this gentleman is.
No, don't confuse. Your review has been dismissed. Nothing has been nothing additional has been mentioned in the review.
May I just
say, please come to page 31.
Page 31.
Why you are avoiding reading that page?
No, there is an order passed by DD after that.
My lord, we are not avoiding. My lord, may come to
please
my
read
affidavit, my lord.
Please read, sir.
Please read page 31, paragraph 2.
But it says in compliance with such order, the registrar has identified 125 members who have a rightful claim to the 125 which are available.
Yes, next then.
But we are informed that allotment of the said 120 was made by petitioner DDA in favor of 120 identified members of the cooperative society upon draft lots being conducted, but that possession could not be handed over to some. We direct the DDA to honor the allotment made and to ensure that those members who were not given delivery of possession allotted in their favor are delivered possession thereof. But
This is in respect of 120 only.
120.
This is in respect of 120.
This is not in the RCS list, my lord. The RCS has given us a list. My lord, look at the affidavit, my lord. We are not stopping anybody's claim to possession, my lord. What will we do with those flats?
Mr. Vice Chairman. What is the name of the Vice Chairman?
My lord, just look at an affidavit,
my lord. What is the name of the Vice Chairman? Give the name of the Vice Chairman.
The commissioner may be, my lord, then.
Before your
Commissioner, let the Vice Chairman come.
Can I say two sentences?
No, please, we are very sorry.
In a contempt petition, there cannot be any inclement.
No,
Between the court and the contemptor.
I fully agree, madam. I fully agree, madam. I fully agree. I'm only trying to assist the court.
The contemptor, the petitioner is only in the position of an informer. His role is over now. We will.
No, I 100% agree with your lordship. Yes, bow down to your lordship.
Who is the gentleman who is authorized or empowered to take action in terms of our order? We will comply with our order. Tell us his name.
The Commissioner Alien, my lords.
Commissioner, the Vice Chairman.
Commissioner,
there is some factual question not been
please,
I just want to show that to the
my lord, actually, I am 56.1. Mr. Sarvana Kumar is the Vice Chairman of DDA.
Mr. Sarvana Kumar, Vice Chairman, Delhi Development Authority, shall remain personally present in court on 26th May at 10:30 a.m.
Grateful.
May I just take matters to my affidavit, my lords?
No, we will not see the affidavit because the order passed by this court is very clear.
Can I assist your lordships with some facts?
No, not required. Don't intrude, sir.
No, not one second. If your lordships permit me.
No, very sorry. Very sorry.
Something.
We are muting everybody because you are not allowing us to dictate our order.
No, I am sorry, my lord. I will not.
Please, for explaining as to why proceedings for contempt shall not be drawn up against him for acting in willful and deliberate breach of the order dated
page 31.
20th November 2024, passed by this court. Let him come personally and explain. Thereafter, we'll send.
Grateful minutes.
Yes, next.
I'm for the petitioner in item 57, my lords.
My lords, in item 57, I beg to appear for the respondents. We've been recently engaged and seek some time to file a reply and
reply by 31st July, rejoinder by 14th August, release thereafter.
But in this, the insurance company has taken a plea that the truck was seized and was lying with the police on the date the accident took place.
My lords.
So no. So state is not a party. We would like the state also to file a reply whether the truck was seized by the police and it was lying in the police station or not, because that's a very important problem.
In view of the case made out in the special petition by the petitioner, we require the petitioner to impede the state of.
Which state, madam?
Uttar Pradesh.
UP, minutes.
State of Uttar Pradesh to be implemented as an additional respondent. Amended memo of parties be filed within 7 days. What you found out first.
Government shall file an affidavit stating categorically whether on the date of accident the truck was under the police custody as it was seized on account of some other accident or not.
My lords, who is to file this affidavit?
State
I'm
of
sorry.
Madhya Pradesh. State of Madhya Pradesh. Sorry,
All
State of Uttar Pradesh.
State of Uttar
Yes.
Pradesh, but the amendment be carried out in the cost title.
Very well.
Next, State of Uttar Pradesh, a party, file your amended memo of parties within 7 days and effect service with this order.
My lords.
58.
Wait, please, my lords. We have complied with the order of your lordships, my lords, which is dated 30th of April 26. Office report indicates that the service is still not complete, my lords. So your lordships. Otherwise, we've deposited the money in compliance of the 30th April order and the 16/3/26 order.
16th March order.
Yes, my lord. 16 March required us to deposit the
75% of the enhanced amount.
Yes, we've deposited that after your lordships were pleased to extend the period, my lords. Office report indicates that we filed an affidavit to that effect.
The petitioner submits that in compliance with the order dated 16th March, 75% of the enhanced amount of compensation has since been deposited with the executing court.
Yes, my lords.
Within the extended time granted by this court. Notice has been issued?
Yes, my lords, but service is not complete.
Very well. Since service is not complete, fresh steps may be taken for effecting service. Released after the partial work.
Lordship pleases. Oblige, my lords.
My lord, in item 56, my lord, 56.1 was also connected, my lord. Kindly similar order be ordered to pass, my lord. Contempt matter.
56 and 56.1 together.
Yes, my lord.
56.2, who is in 56.2?
So I do not know, my lord. I appear in 56.1 only.
That's a 56.
My lord has directed to come in person.
56.2 के साथ order लिखिए. Shall explain his conduct as to why, in willful breach and default of the order dated so and so, possession of the identified flats has not been made over to Lokinder Singh Verma and Dinesh Saxena.
Yes, my lord. Obliged. Very much obliged.
In item 59, my lords.
Yes.
In item
Lordship,
59,
this matter is regarding unauthorized long absence without sanctioned leave. Lordship, it constitutes the misconduct and reflects lack of devotion and duty, Lordship. We had even published in the newspaper after 4 months that the person
But you
is
lost
not...
it from all courts, all the courts.
No, Lordship. What happened, Lordship? In labor court, they had taken only the ground of quantum of punishment, Lordship, not on the
What
facts
was the order
submitted
of
by
the
the
labor
petitioner.
court?
Lordship, that they said that because they
what is the
admitted fact
final
in para
outcome?
number 5.
What was the
Yeah,
final
Lordship.
order?
Lordship, they said that let him continue because
He succeeded ultimately. So, and what
no,
happened in the
Lordship.
High
No,
Court?
Lordship. What he quantum of punishment only he was objecting, not that it was the admitted fact that yes, he did not join. And Lordship, everything was done according to principle of natural justice. There were witnesses, there were even inquiry. Everything had happened, but he did not appear in anything even after the publication in the newspaper, Lordship.
You filed your SLP with a delay of 346 days.
Lordship.
And got a condemnation on the first day without the respondent being put on notice, which is contrary to the Supreme Court rules.
Lordship, but there were grounds that's why.
Be that as it may, by a further order, we said that the parties should arrive at a settlement so that lump sum compensation can be paid and the proceedings brought to a close.
Lordship, may I
Has there
submit?
been any development on that front?
Lordship, may I submit, Lordship? Lordship, what is happening? These people, when they join, only after 2 months or 3 months, they are then absconding from the duty.
Madam, you are
and
arguing
we have
on
got
merits. You are
Lordship.
arguing on merits. If there is no talk of an amicable settlement, we will recall that order issuing notice and call upon you to explain the delay of 346 days. If we are not satisfied, your SLP will fail only on the ground of delay.
Lordship.
So it's better instead of arguing on merits, you tell
Lordship.
us what are the developments post our order requiring lump sum payment.
Lordship.
Has any development taken place?
Lordship, I have spoken to the department, Lordship. There is no problem, Lordship. Whatever the court instructs us, that is okay, Lordship.
Who is the other side?
Milord, I am appearing for the respondent who is 87 years old. Milord, they had been contesting this case for last 32 years as the award was passed in 1994. Milord, I am 87 years old now. Milord,
Madam
Sangeeta Kumar.
Bharadwaj,
Lordship.
Madam, ask your accounts officer to
Lordship.
go to the residence of the respondent
Lordship.
and talk to him. He is 87 years old. He may not be in a position to go to your office. Your
Lordship.
officer will go to his house,
Okay, Lordship.
find out what is an acceptable solution, come back next Monday.
Lordship may be granted at least till Thursday or Friday, Lordship.
Next Monday it will come up.
Okay,
Your
Lordship.
accounts officer go during the weekend
Lordship.
and report
Lordship.
to us on Monday next.
Oblige, Lordship.
Counsel for the respondent,
Lordship, please.
are they complying 17B?
No, Milords, not at all.
Oh, that also they're not doing.
They are not doing it, Milords.
Lordship, it was just a fact that it is very clearly given in standard rules that even after joining such drivers...
It is the statutory ordainment that any matter is pending before the High Court or the Supreme Court. You are
Lordship.
under an obligation to pay the last wages drawn.
And I want to correct you. Labor court, he succeeded. There was a direction for reinstatement. However, back wages were not given to him. In High Court, again he succeeded. Your petition was dismissed. And
No,
you
Lordship,
say,
that is only on the
what does
non-prosecution.
it mean? It has not been dismissed.
No, Lordship, it was not decided on merits,
Was
but
it
only on
dismissed
the
or allowed?
non-prosecution.
Only two words I'm asking.
No, Lordship, it was dismissed,
Why
Lordship.
unnecessarily you are doing all this?
Monday next.
Okay, Lordship. I will be here, Lordship, on Monday.
While we grant one last opportunity to the petitioner to get in touch with the respondent and negotiate for an amicable settlement between the parties.
Lordship, one more request that the address may be provided because we really tried hard in last all these months
Milords, this is another
to
way,
approach him.
It's appropriate.
To approach him.
another way of really not...
So far as the address where the respondent is presently residing, Madam Garg shall inform the address to Madam Bhardwaj in course of tomorrow.
It's a legal aid matter, Milords. It's a legal aid matter. Milords. I will certainly provide her the address, but Milords, may I just say, I am 87 years old. 94 is the award passed. 32 years they had.
Very well,
been
Madam.
prosecuted.
Madam, try to get the address of your client, right, and inform it to Ms. Bharadwaj. Let us give them one opportunity, otherwise consequences will follow.
Lordship, please. Deeply obliged, Milords.
Oblige, Lordship.
का इसका एड्रेस अभी इसका उनसे मांगोगे
Address you have to provide to me because otherwise even our letters are not reaching to him.
In item number 68, I appeared, Court Master Sir. My name, it's not going to the court.
Item mentioning item number 13. Court has an over. Item 39.
Master Sahab,
Item number 39.
the court been dismissed or
Dismiss.
it is
Dismiss.
for the lunch?
No, dismiss. Court is discharged. Court is a final.
But the numbers, password numbers has not been called yet.
It's called, sir. It's called.
No,
Please
I
check
mention is
No,
twice
no.
or thrice.
Check the sequence. Wait a minute. मैं आपको डायरेक्ट मैसेज कर रहा हूँ सीक्वेंस इस हिसाब से हो गया है पासवर्ड
नहीं मैंने 4 बार उसको ये करा है कॉल करा है कॉल आउट
तो
करा है
सर
बस mention
ये
करा है।
तो अब ऑनरेबल जज ने नहीं सुना तो क्या ही बोल सकते हैं सॉरी सर
उसमें डेट क्या लगी है
इतना नहीं पता आप कांटेक्ट टू द कोर्ट मास्टर से कर लें अभी 20 मिनट 25 मिनट के बाद
Sir, my appearance in court, item number 68, sir.
sir contact to the court master sir. Thank you sir.
जी,
Please contact to the court master.
तो मैं
Please contact to the court master sir. Thank you.
हेलो स्टूडेंट्स, वेलकम टू मैग्नेट ब्रेन्स। कैसे हैं आप सभी लोग? आई होप आप सब बढ़िया होंगे। आज की वीडियो स्टार्ट करने से पहले मैं आपको बता देती हूँ, मैग्नेट ब्रेन्स आपको प्रोवाइड कराता है फ्री ऑफ कॉस्ट क्वालिटी एजुकेशन फ्रॉम क्लास के टू क्लास 12th। जी हाँ, सही सुना आपने, किंडरगार्टन से लेकर क्लास 12 तक की कराई जाती है आपको कंप्लीट एजुकेशन, वो भी फ्री ऑफ कॉस्ट प्रोवाइड। तो करना क्या है, आपको यूट्यूब चैनल पर जाना है एंड कर देना है मैग्नेट ब्रेन्स को सब्सक्राइब, जहां पर आपको सीबीएसई बोर्ड से लेकर अदर स्टेट बोर्ड जैसे कि यूपी बोर्ड, एमपी बोर्ड, बिहार बोर्ड जैसे कोर्सेज भी अवेलेबल हैं। यहां तक कि आपको प्रैक्टिस क्वेश्चंस भी यहां पर सॉल्व कराए जाते हैं। ई बुक्स एंड ई नोट्स की जो लिंक है आपको डिस्क्रिप्शन बॉक्स में मिल जाएगी। तो करते हैं आज की वीडियो स्टार्ट। मेरा नाम है हशमित कौर एंड मैं हूं आपकी मैथ्स फैकल्टी। तो आज हम क्या पढ़ने वाले हैं? आज हम पढ़ेंगे चैप्टर फर्स्ट, जिसका नाम क्या है, पैटर्न्स इन मैथमेटिक्स, उसका कंप्लीट चैप्टर रिवीजन। इसका मतलब क्या है, ये चैप्टर हम पूरे तरीके से कंप्लीट कर चुके हैं। इसमें जितने भी कॉन्सेप्ट्स दे के रखे हुए थे, फिगर इट आउट में जितने भी क्वेश्चंस थे एंड इवन जो इन टेक्स्ट क्वेश्चंस थे वो भी हमने सॉल्व कर लिए हैं। ठीक है, तो अगर आपने डिटेल में ये चैप्टर नहीं पढ़ा है, सबसे पहले आपको वही पढ़ना है। वीडियोज़ अच्छी लगे तो वीडियोज़ को लाइक, कॉमेंट एंड शेयर करना है। उसके बाद हमने मल्टीपल चॉइस क्वेश्चंस भी सॉल्व किए थे, जो एग्जामिनर आपसे एक एक मार्क्स के लिए पूछ सकता है। एंड साथ ही में हमने मोस्ट इम्पॉर्टेंट क्वेश्चंस भी सॉल्व कर लिए हैं, जो आपके एग्जाम में आ सकते हैं। तो आपको सभी चीज़ें अच्छे से पढ़नी है। एंड जैसे कि मैंने आपको प्रॉमिस किया था, जैसे ही पूरा चैप्टर हो जाएगा, MCQs MIQs हो जाएंगे, तो मैं आपको चैप्टर रिवीजन भी करवाऊंगी, ताकि जो भी आपने पढ़ा है वो एक बार फिर से आपको रिकॉल हो जाए एंड आपके दिमाग में फिट हो जाए। ठीक है, तो आज हम चैप्टर रिवीजन ही पढ़ने वाले हैं। ठीक है, चलिए सबसे पहले तो हम देख लेते हैं चैप्टर ओवरव्यू, मतलब चैप्टर में हम क्या क्या कवर करने वाले हैं। तो सबसे पहला टॉपिक है व्हाट इज़ मैथमेटिक्स। हम मैथ्स पढ़ रहे हैं, तो मैथमेटिक्स का मतलब क्या है ये हम इस चैप्टर में सबसे पहले समझेंगे। ठीक है, एंड देन उसके बाद टॉपिक क्या है, पैटर्न्स इन नंबर्स। नंबर्स में क्या पैटर्न्स रहते हैं वो हम यहाँ पे पढ़ने वाले हैं। विजुअलाइजिंग नंबर सीक्वेंस, नंबर सीक्वेंस को हम कैसे विजुअलाइज करेंगे वो हम इस टॉपिक में पढ़ने वाले हैं। ठीक है, रिलेशंस अमंग नंबर सीक्वेंस में रिलेशन क्या है वो हम इस टॉपिक में पढ़ने वाले हैं। ठीक है, पैटर्न इन शेप्स, नंबर्स के अलावा शेप्स में भी पैटर्न्स रहते हैं, तो उन पैटर्न्स को हम यहाँ पर इस टॉपिक में एनालाइज करेंगे। ठीक है, रिलेशन टू नंबर सीक्वेंस, एंड नंबर सीक्वेंस में क्या रिलेशन है वो हम इस टॉपिक में पढ़ेंगे। एंड फिगर इट आउट के क्वेश्चंस भी हर टॉपिक के साथ सॉल्व करते जाएंगे। ठीक है, आया समझ में? चलिए सबसे पहले हम देख लेते हैं व्हाट इज मैथमेटिक्स। मैथमेटिक्स है क्या? मैथमेटिक्स इज इन लार्ज पार्ट द सर्च फॉर पैटर्न्स। सबसे पहले तो अगर हम बड़े क्राइटेरिया से समझे तो मैथमेटिक्स क्या है, मैथमेटिक्स पैटर्न्स को सर्च करता है एंड फॉर द एक्सप्लेनेशन एज टू व्हाई दोज पैटर्न एग्जिस्ट। पैटर्न सर्च तो करता है, लेकिन वो पैटर्न एग्जिस्ट क्यों कर रहे हैं इसका एक्सप्लेनेशन भी मैथमेटिक्स देता है। ठीक है, सच पैटर्न्स इंडीड एग्जिस्ट ऑल अराउंड अस, और ऐसे पैटर्न्स जो हैं वो हमें हर जगह हमारे आसपास देखने को मिल जाते हैं। इन नेचर में भी हमें पैटर्न्स देखने को मिलते हैं। इन आवर होम्स, हमारे घर पे भी हमें पैटर्न्स देखने को मिलते हैं। स्कूल्स एंड इन द मोशन ऑफ द सन, मून एंड स्टार, जो सन, मून एंड स्टार का मोशन रहता है ना, उसमें भी हमें पैटर्न्स देखने को मिलते हैं। मतलब हमारे पास हर जगह हमें पैटर्न देखने को मिल ही जाएंगे। ठीक है, आया समझ में? दे ऑकर इन एवरीथिंग दैट वी डू एंड सी, मतलब ये जो पैटर्न्स रहते हैं ये हर जगह में देखने को मिलते हैं। जो भी हम कर रहे हैं उसमें भी पैटर्न देखने को मिलेंगे, एंड जो भी हम देख रहे हैं उसमें भी पैटर्न देखने को मिल जाते हैं। ठीक है, फ्रॉम शॉपिंग एंड कुकिंग टू थ्रोइंग अ बॉल एंड प्लेइंग गेम्स। इवन हम जब शॉपिंग करने जाते हैं या फिर कुकिंग करते हैं उसमें भी हमें पैटर्न्स देखने को मिलते हैं। टू थ्रोइंग अ बॉल, एंड जब हम बॉल फेंक रहे हैं या फिर गेम खेल रहे हैं उसमें भी हमें पैटर्न देखने को मिलते हैं। टू अंडरस्टैंडिंग वेदर पैटर्न्स, वेदर फोरकास्ट के जो पैटर्न्स रहते हैं उसमें भी हमें पैटर्न्स देखने को मिलते हैं। एंड यूजिंग टेक्नोलॉजी, एंड टेक्नोलॉजी में भी हमें पैटर्न्स देखने को मिल जाते हैं। मतलब मैथमेटिक्स का रोल हर जगह हमें देखने को मिल जाता है। शॉपिंग में कैसे, जैसे कि प्राइजेस लिखे रहते हैं वो रुपीज़ में रहते हैं, उसमें भी मैथमेटिक्स के पैटर्न्स रहते हैं, डिस्काउंट दे दिए जाते हैं आपको। एंड कुकिंग में बात करी जाए तो आप जब सब्जी बनाते हो तो उसमें कितने इंग्रेडिएंट्स डलेंगे, मतलब कितने स्पून नमक डल रहा है, कितने स्पून मिर्च डल रहा है, तो ये सब क्या है, ये सब पैटर्न है, मैथमेटिक्स के ही पैटर्न है। ठीक है, आया समझ में? तो ये सब हमें दे के रखा हुआ है मैथमेटिक्स के बारे में, तो फटाफट से आप इसे सबसे पहले नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन? और वीडियो अच्छी लग रही है तो जल्दी से वीडियो को लाइक, कमेंट एंड शेयर भी कर दीजिए। ठीक है, नेक्स्ट क्या है, इट इज़ इम्पॉर्टेंट टू कीप इन माइंड दैट मैथमेटिक्स एम टू नॉट जस्ट टू फाइंड आउट व्हाट पैटर्न एग्जिस्ट बट ऑल्सो द एक्सप्लेनेशन फॉर व्हाई दे एग्जिस्ट। बोला जा रहा है, हमें ये ध्यान रखना है कि मैथमेटिक्स का सिर्फ यही एम नहीं है कि हमें पैटर्न्स निकालने या कौन से पैटर्न्स एग्जिस्ट करते हैं, बल्कि उनका रोल ये भी है कि उन पैटर्न्स को एक्सप्लेन करना कि क्यों वो पैटर्न एग्जिस्ट करते हैं। पैटर्न एग्जिस्ट कर रहे हैं दैट्स ओके, लेकिन क्यों कर रहे हैं वो भी मैथमेटिक्स खोजता है। ठीक है, आया समझ में? मतलब अगर हम बात करें पैटर्न्स की बात करें तो दो चीज फाइंड आउट करता है मैथमेटिक्स। सबसे पहले तो व्हाट, कौन सा पैटर्न है, एंड सेकंड व्हाई, और वो पैटर्न क्यों एग्जिस्ट कर रहा है। ठीक है, ये दो चीज कौन फाइंड आउट करता है? मैथमेटिक्स। ठीक है, for example, the understanding of patterns in the motion of stars, planets and their satellites led humankind to develop the theory of gravitation। मतलब जो हम motion of stars में पैटर्न समझते हैं या फिर planets में पैटर्न समझते हैं, satellites में पैटर्न समझते हैं, उससे क्या डेवलप होता है? थ्योरी ऑफ ग्रेविटेशन डेवलप होता है। ये जो ग्रेविटेशन है इसके बारे में आपने साइंस में पढ़ा होगा कहीं ना कहीं, और नहीं पढ़ा है तो आप आगे पढ़ोगे। ग्रेविटेशन में क्या रहता है? थ्योरी ऑफ ग्रेविटेशन में आपने देखा होगा, आप बॉल को ऊपर फेंकते हो तो नीचे ही आता है, मतलब किसी भी चीज़ को आप ऊपर की तरफ फेंकोगे तो नीचे ही आएगा, बिकॉज ऑफ द ग्रेविटी रहती है जो उसे नीचे खींचती है, कभी भी वो हवा में नहीं रहती। कोई भी चीज़ आप ऊपर फेंकोगे वो ऊपर ही नहीं जाएगी और ना ही हवा में रहेगी, वो नीचे आएगी बिकॉज ऑफ द ग्रेविटी। उसे हम बोलते हैं थ्योरी ऑफ ग्रेविटेशन। ठीक है, allowing us to launch our own satellites and send rockets to the moon and to Mars। अगर हम इन पैटर्न्स को समझ गए, स्टार्स में, मोशन ऑफ स्टार्स में और प्लैनेट्स में और सैटेलाइट्स में क्या पैटर्न है, अगर हम उन्हें समझ लिए तो थ्योरी ऑफ ग्रेविटेशन के साथ साथ हम हमारी सैटेलाइट्स को भी लॉन्च कर सकते हैं एंड रॉकेट्स को मून्स एंड मार्स पे भी भेज सकते हैं। ठीक है, आया समझ में? आया है तो फटाफट से आप इसे नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन? चलिए, अब नेक्स्ट क्या देखे रखा है हमें, फिगर इट आउट का क्वेश्चन फर्स्ट क्या है, कैन यू थिंक ऑफ अदर एग्जांपल्स वेयर मैथमेटिक्स हेल्प अस इन आवर एवरीडे लिव्स। मतलब बोला जा रहा है कि हमें क्या बताने हैं, एग्जांपल्स बताने हैं जहाँ पर मैथमेटिक्स हमें हेल्प करता है। ठीक है, आया समझ में? चलिए, तो यहाँ पर हम आंसर देख लेते हैं। सबसे पहले हमें दे के रखा है व्हेन यू आर शॉपिंग। जब आप शॉपिंग करते हो तब भी आपको मैथमेटिक्स देखने को मिल जाती होगी। क्यों? क्योंकि अगर हम बात करते हैं शॉपिंग की तो उसमें क्या रहता है, सबसे पहले तो प्राइस रहता है। जैसे कि आप एक शर्ट खरीद के आए तो उसका प्राइस क्या है? उसका प्राइस है ₹1000 एंड देन फिर आपने उस एक की जगह 2 शर्ट्स खरीद ली तो उसका प्राइस क्या रहेगा? 1000 मल्टीप्लाई बाई 2 ₹2000। तो ये जो टर्म्स है ये आपको मैथमेटिकल टर्म्स ही दिख रहे होंगे। मतलब मैथमेटिक्स जो है वो शॉपिंग में भी हेल्प करती है। इवन आपको शॉपिंग करते वक्त डिस्काउंट रेट्स भी मिलते होंगे, डिस्काउंट परसेंट या फिर देके रखा होता है, या फिर फ्लैट ₹100 ऐसे करके भी लिखा रहता है। सपोज कीजिए आपको डिस्काउंट परसेंट कितना मिल रहा है? 10%। तो जो आप एक शर्ट खरीद कर ला रहे हो 1000 में, तो वो आपको कितने की मिल जाएगी? अगर उस पर 10% डिस्काउंट लगता है तो उसकी प्राइस क्या हो जाएगी? 10% डिस्काउंट लगने के बाद उसकी प्राइस हो जाएगी ₹900। क्या हो जाएगी ₹900, क्योंकि अगर आप 1000 में 10% निकालोगे तो आपका आएगा ₹100, ठीक है। परसेंटेज निकालना आपको शायद नहीं आता है तो मैं डायरेक्टली यहाँ पे लिख रही हूँ, आता है तो वेल एंड गुड। अगर आप 1000 रुपीज़ में 10% लगाते हो डिस्काउंट तो आपको वो जो शर्ट है कितने की मिल जाएगी, ₹900 की। और अगर 2000 में 10% निकालते हो तो आपको जो 2 शर्ट्स हैं वो कितने की मिलेंगी, ₹1800, ठीक है। आया समझ में? तो ये सारे ही क्या है, मैथमेटिकल टर्म्स हैं, ठीक है। आया समझ में? नेक्स्ट हम देख लेते हैं व्हेन यू आर कुकिंग और बेकिंग, मतलब जब आप कुकिंग करते हो या बेकिंग करते हो तब भी आपको क्या देखने को मिलते हैं, मतलब मैथमेटिकल टर्म्स देखने को मिलते हैं, वो आपको हेल्प करते हैं। जैसे कि कुकिंग करने में अगर आप कम कुछ क्वांटिटी में चीज़ बना रहे हो, सब्ज़ी बना रहे हो, सपोज़ कीजिए अगर आप कम सब्ज़ी बना रहे हो तो आपका आधा चम्मच नमक लगेगा, आधा चम्मच मिर्च लगेगी। लेकिन अगर आप ज़्यादा सब्ज़ी बना रहे हो, ज़्यादा लोगों के लिए बना रहे हो तो वहीं आपको एक चम्मच मिर्च लग सकती है, 1 चम्मच नमक लग सकता है। तो ये सब क्या है, मैथमेटिकल टर्म्स हैं, ठीक है। एंड बेकिंग करते वक्त आपको मिल्क की ज़रूरत पड़ती है तो उसको क्वांटिटी में नापना, कितना लीटर मिल्क लगेगा, ठीक है, कितना ग्लास मिल्क लगेगा। तो इसमें भी क्या आते हैं, मैथमेटिकल टर्म्स आते हैं, ठीक है। आया समझ में? चलिए थर्ड पॉइंट क्या है, व्हेन यू आर लिसनिंग टू म्यूजिक, जब आप म्यूजिक सुनते हो तो उसमें भी मैथ्स रहती है, उसमें भी पैटर्न्स रहते हैं। एंड इवन जब आप डांस करते हो तो आप स्टेप्स के थ्रू करते हो, 1 2 3 4। आप अगर डांस क्लास में गए होंगे तो आपने एनालाइज किया होगा कि वो स्टेप्स के थ्रू समझाते हैं, 1 2 3 4। तो इसमें भी क्या चीज़ यूज़ हो रही है, मैथ्स का यूज़ हो रहा है, ठीक है। आया समझ में? द नेक्स्ट पॉइंट क्या है, व्हेन यू आर वर्किंग आउट, जब आप वर्कआउट करते हो तो आपने देखा होगा वर्कआउट करते वक्त भी क्या होता है, मैथ्स का ही यूज़ होता है। कैसे? आप ऐसे मतलब वो बना लेते हो कि मैं इस एक्सरसाइज को, सपोज कीजिए आप एक्सरसाइज कर रहे हो, डंबल्स उठा रहे हो, तो आप सोच लेते हो कि मैं 20 टाइम्स इसे उठाऊंगा, तो आप काउंट करने लगते हो। इवन आप रेसिंग करने जा रहे हो या साइकिलिंग करने जा रहे हो तो आप आवर्स के बेस पे, ठीक है, या फिर डिस्टेंस के बेस पे डिसाइड कर लेते हो कि मुझे आज इतना वॉक करना ही है, इतना जॉगिंग करना ही है। तो ये सब क्या है, मैथमेटिकल टर्म्स है। या फिर आप टाइम देख लेते हो कि आधे घंटे तक मैं वॉक करूँगा, आधे घंटे तक मैं रनिंग करूँगा, या आधे घंटे तक मैं साइकिलिंग करूँगा। तो इन सब चीज़ों में भी हमें मैथ्स देखने को मिल जाता है। टाइम हो गया, ठीक है, डिस्टेंस हो गया तो मीटर किलोमीटर में रहता है। अगर टाइम हो गया तो वो भी, जैसे कि आधा घंटे की बात करो तो उसमें रहता है 30 मिनट्स, उसमें क्या रहता है 30 मिनट्स। तो ये सब भी क्या है, ये भी मैथ्स का ही पैटर्न है, ठीक है। आया समझ में? व्हेन यू आर प्लेइंग वीडियो गेम्स, अगर हम बात करें वीडियो गेम्स की तो उसमें भी आपको मैथ्स देखने को मिल जाएगी, क्योंकि वीडियो गेम्स जब आप खेलते हो तो आपको पजल्स, लेफ्ट जाना है, राइट जाना है, या फिर पजल गेम दे के रखे होते हैं, उसके स्टेप्स दे के रखे होते हैं कि ये स्टेप फॉलो करोगे तो यहाँ पहुँच जाओगे, ये स्टेप फॉलो करोगे तो विन कर जाओगे। तो इसमें भी क्या देखने को मिलता है, मैथ्स देखने को मिलता है। एंड कुछ पजल्स तो ऐसे होते हैं जिसमें मैथमेटिकल क्वेश्चंस ही रहते हैं, ठीक है। आया समझ में? तो इन सब चीज़ों के अलावा और भी चीज़ें रहती हैं जिसमें हमें मैथ्स देखने को मिल ही जाती है। आप उन्हें भी यहाँ पर लिख सकते हो, ऐड कर सकते हो, ज़रूरी नहीं आपको यही आंसर लिखना है, ठीक है। ये मैंने एज रेफरेंस आपको दिया है, तो फटाफट से आप इसे नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन? और वीडियो अच्छी लग रही है तो आपको क्या करना है, जल्दी से वीडियो को लाइक, कमेंट एंड शेयर भी कर देना है, ठीक है। चलिए नेक्स्ट हम देखते हैं पैटर्न्स इन नंबर्स। नंबर्स में क्या पैटर्न रहते हैं वो हम देख लेते हैं। अमंग द मोस्ट बेसिक पैटर्न दैट ऑकर इन मैथमेटिक्स आर पैटर्न ऑफ नंबर। सबसे बेसिक पैटर्न मैथमेटिक्स का क्या रहता है, पैटर्न्स ऑफ नंबर्स, ठीक है। पर्टिकुलरली पैटर्न ऑफ होल नंबर्स, और बोला जाए तो होल नंबर्स का सबसे पहले हमें देखा जाता है पैटर्न, ठीक है। आया समझ में? अब आप सोच रहे होंगे होल नंबर्स क्या होते हैं, तो यहाँ पर सबसे पहले हम बात करते हैं नेचुरल नंबर की, देन फिर हम आएंगे होल नंबर्स पर। तो अगर हम नेचुरल नंबर की बात करते हैं तो नेचुरल नंबर क्या होता है, जितने भी काउंटिंग नंबर्स रहते हैं ना, ऑल काउंटिंग नंबर्स आर कॉल्ड नेचुरल नंबर्स। ऑल काउंटिंग नंबर्स आर कॉल्ड नेचुरल नंबर्स। फॉर एग्जाम्पल अगर हम बात करें 1 2 3 4, ये सब क्या है, ये काउंटिंग नंबर्स हैं, इन्हें हम काउंट कर सकते हैं। लेकिन ज़ीरो की बात करें, क्या हम ज़ीरो को काउंट कर सकते हैं? नहीं कर सकते, तो वो नेचुरल नंबर में इंक्लूड नहीं होगा। लेकिन अगर हम बात करें होल नंबर्स की, किसकी बात कर रहे हो, अगर हम बात करते हैं होल नंबर्स की, ठीक है, तो होल नंबर्स में क्या क्या आ जाता है, 0 आ जाता है एंड सारे ही नेचुरल नंबर एंड ऑल नेचुरल नंबर्स इसमें इंक्लूड हो जाते हैं, ठीक है। अगर एग्जाम्पल की बात करते हैं तो एग्जाम्पल क्या हो जाएगा, 0 1 2 3 4 एक्सेट्रा। यहाँ पर आप देख सकते हो कि 0 से स्टार्ट हो रहा है एंड जितने भी नेचुरल नंबर्स हमने यहाँ पे लिखे 1 2 3 4 ये भी किस में आ जाएंगे, होल नंबर्स में आ जाएंगे। तो बोला जा रहा है मैथ्स में क्या रहता है, पैटर्न ऑफ नंबर्स, जो कि पर्टिकुलरली किससे स्टार्ट हो रहा है, होल नंबर से स्टार्ट हो रहा है, ठीक है। जैसे कि 0 1 2 3 4 इसमें आप देख सकते हो पैटर्न लगा हुआ है, सीक्वेंस में जा रहा है पैटर्न, 0 1 2 सारे काउंटिंग नंबर्स 0 के बाद हमें दिख रहे हैं, ठीक है। आया समझ में, चलिए देन उसके बाद द ब्रांच ऑफ मैथमेटिक्स दैट स्टडीज पैटर्न इन होल नंबर इज कॉल्ड नंबर थ्योरी। बोला जा रहा है जो ब्रांच मैथमेटिक्स की रहती है, जो पैटर्न्स में स्टडी करती है, जो कि स्टडी करती है पैटर्न्स में, वो भी होल नंबर के, तो उसे हम क्या बोलते हैं, उसे हम नंबर थ्योरी बोलते हैं, ठीक है। आया समझ में। फिर उसके बाद क्या है, नंबर सीक्वेंसेस आर द मोस्ट बेसिक एंड अमंग द मोस्ट फैसिनेटिंग टाइप्स ऑफ पैटर्न्स दैट मैथमेटिशियंस स्टडी। बोला जा रहा है जो नंबर सीक्वेंस रहते हैं ना, नंबर के जो सीक्वेंस रहते हैं वो सबसे बेसिक एंड बहुत ही ज़्यादा फैसिनेटिंग इंटरेस्टिंग पैटर्न्स रहते हैं जो कि मैथमेटिशियंस स्टडी करते हैं, ठीक है। आया समझ में। टेबल 1 शोज सम की नंबर सीक्वेंस दैट आर स्टडी इन मैथमेटिक्स। बोला जा रहा है कि अभी हम क्या पढ़ेंगे, टेबल 1 पढ़ेंगे, जिसमें हम क्या देखेंगे, नंबर सीक्वेंस देखेंगे जो कि मैथमेटिक्स में पढ़े जाते हैं, ठीक है। इतना आया समझ में, आया है तो फटाफट से नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन, चलिए अब नेक्स्ट क्या है, यहाँ पर हमें टेबल देके रखी हुई है, टेबल 1 एग्जाम्पल्स ऑफ नंबर सीक्वेंसेस, एंड यहाँ पर हमें कुछ नंबर सीक्वेंसेस देके रखे हुए हैं, ठीक है। यहाँ पर सबसे पहले आप देख सकते हो, आपको 1 की सीरीज़ यहाँ पे दिखेगी, तो ये क्या है, ऑल वंस, सारे ही 1 1 1 1 देके रखे हुए हैं, ठीक है। आया समझ में। ये भी क्या है, ये भी नंबर सीक्वेंस है। उसके बाद नेक्स्ट आपको दिख रहा होगा 1 2 3 4 5 6 7 सीक्वेंस में आपको नंबर्स देके रखे हुए हैं, इन्हें हम क्या बोलते हैं, इन्हें हम काउंटिंग नंबर्स बोलते हैं। एंड काउंटिंग नंबर्स क्या होते हैं, नेचुरल नंबर्स होते हैं। तो आप देख सकते हो ये नेचुरल नंबर की सीरीज़ है, ये काउंटिंग नंबर की सीरीज़ है, ठीक है। आया समझ में। चलिए नेक्स्ट क्या है, 1 3 5 7 9 11 13 आप देख पाओगे हर एक नंबर छोड़ के यहाँ पर नंबर दे के रखा है। स्टार्ट कहाँ से हो रहा है, 1 से हो रहा है, 1 एंड उसके बाद 2 आता है, 2 नहीं दे के रखा, फिर 3, फिर 4 नहीं दे के रखा, 5, फिर 6 नहीं दे के रखा हुआ है, फिर 7, 8 नहीं दिया, 9, 10 नहीं दिया, 11, 12 नहीं दिया एंड 13 है। तो ये क्या है, इन्हें हम बोलते हैं ऑड नंबर्स। इन्हें हम क्या बोलते हैं, ऑड नंबर्स बोलते हैं। ऑड नंबर्स क्यों बोलते हैं, 0 2 4 6 8 ये सारे ही क्या है, ये सारे ही इवन नंबर्स हैं। ये सारे क्या है, ये सारे हैं इवन नंबर्स, या फिर हम बोल सकते हैं जो नंबर्स 2 के मल्टीपल्स नहीं होते, 2 की टेबल में नहीं आते, वो ऑड नंबर्स होते हैं, ठीक है। एंड जो 2 की टेबल में आते हैं, 2 के मल्टीपल्स होते हैं, उन्हें हम इवन नंबर्स बोलते हैं, ठीक है। तो 2 की टेबल में 1 नहीं आता, 3 नहीं आता, एंड देन उसके बाद 5, एंड देन उसके बाद 7 9, तो ये सारे नंबर्स क्या हैं, ये सारे नंबर्स हैं ऑड नंबर्स, ठीक है। आया समझ में। तो यहाँ पर आप देख पाओगे 1 3 5 7 9 11 13 में से कोई भी नंबर ऐसा नहीं है जो 2 की टेबल में आए, तो ये सारे नंबर्स क्या है, ये सारे नंबर्स हैं ऑड नंबर्स। फिर उसके बाद क्या है, 2 4 6 8 10 12 14 अब इस सीक्वेंस में आप देख पाओगे ये अगेन 1 1 नंबर छोड़ के है, लेकिन स्टार्ट कहाँ से हो रहा है, स्टार्ट हो रहा है 2 से, एंड सारे ही नंबर्स क्या हैं, 2 के मल्टीपल्स हैं, तो ये क्या हो जाएगा, ये हो जाएगा इवन नंबर्स, ठीक है। आया समझ में। चलिए नेक्स्ट अगर हम देखें क्या देखे रखा है, 1 3 6 10 15 21 28 ये क्या है, ये है ट्राइंगुलर नंबर्स। क्या बोलते हैं हम इन्हें, हम इन्हें बोलते हैं ट्राइंगुलर नंबर्स। क्यों ऐसा, क्योंकि सबसे पहले क्या है, क्योंकि जब इन सीक्वेंस के अकॉर्डिंग आप पिक्चराइज करोगे ना तो आपको ट्राइंगल मिलेगा। क्या मिलेगा, ट्राइंगल मिलेगा, ठीक है। सबसे पहले क्या है 1, एंड देन उसके बाद क्या है 1 + 2 = 3, ठीक है। देन उसके बाद क्या है 1 + 2 + 3 = 6। फिर उसके बाद 1 + 2 + 3 + 4 = 10। तो इस सीक्वेंस में आते हैं ट्राइंगुलर नंबर्स। इस सीक्वेंस में आपको क्या दिख रहे होंगे 1 3 6 10। तो ये सभी क्या है, ये सभी हैं ट्राइंगुलर नंबर्स, ठीक है। एंड इस सीक्वेंस के अकॉर्डिंग जब आप इसे पिक्चराइज करोगे तब आपको ट्राइंगल फॉर्म होता भी दिखेगा, ठीक है। करके देख लेते हैं। यहाँ पर सबसे पहले 1 है तो हमने यहाँ पे 1 डॉट लगा दिया। देन उसके बाद 3 दिख रहा है तो 1 2 3 डॉट्स लगा दिए। देन उसके बाद 6 है तो इसी सीक्वेंस में लगाएंगे। सबसे पहले 1 और 2 तो 1 और 2 डॉट्स दिख रहे होंगे। फिर 1 2 3 डॉट्स बनाने हैं तो 1 2 1 2 3 डॉट्स बना दिए, ठीक है। नेक्स्ट क्या है 1 2 3 एंड 4 जिसे प्लस करके 10 आया है तो 1 2 3 4। तो यहाँ पर अगर आप ध्यान से देखोगे तो बन क्या रहा है, यहाँ पे बन रहा है ट्राइंगल। क्या बन रहा है यहाँ पे, ट्राइंगल बन रहा है। यहाँ पर भी आप देख सकते हो ट्राइंगल बन रहा है, यहाँ पे भी ट्राइंगल बन रहा है एंड यहाँ पर भी क्या बन रहा है, ट्राइंगल बन रहा है, ठीक है। आया समझ में? इसलिए इन नंबर्स को हम क्या बोलते हैं, ट्राइंगुलर नंबर्स बोलते हैं, ठीक है। अब आ गया समझ में। चलिए नेक्स्ट पे आते हैं। नेक्स्ट क्या है 1 4 9 16 25 36 एंड 49। ये क्या है, ये है स्क्वायर नंबर्स। अब स्क्वायर नंबर्स क्या होते हैं वो हम अच्छे से अभी समझेंगे। सबसे पहले आप इतना नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन? चलिए अब यहाँ पर हमें क्या देके रखा है, सबसे पहले तो 1, ठीक है। 1 क्या होता है, 1 होता है 1 का स्क्वायर। 1 का स्क्वायर मतलब 1 को जब हम 2 टाइम्स मल्टीप्लाई करेंगे तब जाके आंसर क्या आ जाएगा, 1 आ जाएगा। अब उसके बाद क्या है 4। तो 4 कैसे आता है, जब हम 2 का स्क्वायर करते हैं, मतलब 2 को 2 टाइम्स मल्टीप्लाई करते हैं तो 2 2 आ जाएगा 4, ठीक है। नेक्स्ट क्या है 9। 9 कैसे आता है सॉरी 9 कैसे आता है, जब हम 3 का स्क्वायर करते हैं, मतलब 3 को 2 टाइम्स मल्टीप्लाई करेंगे, 3 × 3 = 9। देन उसके बाद क्या है 16। 16 कैसे आता है, जब हम 4 का स्क्वायर करते हैं, मतलब 4 × 4 कर देंगे तो आ जाएगा 16। फिर नेक्स्ट क्या है 25। 25 कैसे आएगा, जब हम 5 का स्क्वायर करेंगे, मतलब 5 को 2 टाइम्स मल्टीप्लाई करेंगे तो आंसर क्या आ जाएगा 25। देन उसके बाद क्या है 36। 36 कैसे आएगा, जब हम 6 का स्क्वायर करेंगे। ये जो 2 आपको दिख रहा है ना, इसका मतलब क्या है, हम स्क्वायर कर रहे हैं नंबर्स का, ठीक है। मतलब 6 को 2 टाइम्स मल्टीप्लाई करेंगे तो आंसर क्या आएगा 36। फिर उसके बाद क्या है 49। 49 कैसे आएगा, जब हम 7 का स्क्वायर करेंगे, मतलब 7 × 7 करेंगे तो आंसर क्या आएगा 49। तो ये जो सारे नंबर्स आपको दिख रहे हैं 1 4 9 16 25 36 एंड 49, इन सभी नंबर्स को हम क्या बोलते हैं, इन सभी नंबर्स को हम बोलते हैं स्क्वायर नंबर्स। स्क्वायर्स भी बोलते हैं, स्क्वायर नंबर्स भी बोलते हैं, परफेक्ट स्क्वायर भी बोलते हैं और परफेक्ट स्क्वायर भी बोलते हैं। क्यों ऐसा, क्योंकि किसी नेचुरल नंबर का स्क्वायर करके ही हम ये सब नंबर लेकर आ रहे हैं, ठीक है। इतना आ गया, समझ में आया है तो सबसे पहले आप इतना नोट डाउन कर लीजिए। कर लिया आपने नोट डाउन? अब नेक्स्ट हमें देके रखे हुए 1 8 27 64 125 एंड 216। तो इन्हें बोला जा रहा है क्यूब्स, मतलब ये क्यूब्स है। तो ये नंबर कैसे आते हैं, सेम ऐसे ही 1 का क्यूब करेंगे। ये जो 3 आपको पावर दिख रही है ना, क्या बोलते हैं हम उसे, पावर बोलते हैं, ठीक है। ये जो 3 आपको दिख रहा है इसका मतलब क्या, हम क्यूब कर रहे हैं। क्यूब मतलब 1 को हम यहाँ पे 3 टाइम्स मल्टीप्लाई कर देंगे तो आंसर क्या आएगा, 1 ही आएगा, ठीक है। नेक्स्ट हमें क्या दिख रहा है 8 दिख रहा है, तो मतलब हम अब करेंगे 2 का क्यूब, मतलब 2 को 3 टाइम्स मल्टीप्लाई करेंगे तो 2 2 4 4 2 8 आ जाएगा, ठीक है। नेक्स्ट हमें क्या दिख रहा है 27, तो मतलब हम करेंगे यहाँ पे 3 का क्यूब, मतलब 3 को 3 टाइम्स मल्टीप्लाई करेंगे तो 3 3 9 9 3 क्या आएगा 27 आ जाएगा। नेक्स्ट हमें दिख रहा है 64, मतलब अब होगा 4 का क्यूब, मतलब 4 को हम करेंगे 3 टाइम्स मल्टीप्लाई, तो 4 4 जा 16 एंड 16 4 जा कितना आ जाएगा 64 आ जाएगा। नेक्स्ट हमें क्या दिख रहा है 125, मतलब अब हम करेंगे 5 का क्यूब, मतलब 5 को 3 टाइम्स मल्टीप्लाई, तो जब हम ऐसा करेंगे 5 5 जा 25 एंड 25 5 जा क्या आ जाएगा 125 आ जाएगा। ठीक है, नेक्स्ट हमें दिख रहा है 216, इसका मतलब क्या है, अभी हमें करना है 6 का क्यूब, मतलब 6 को 3 टाइम्स मल्टीप्लाई, तो 6 6 जा आएगा 36, 36 6 जा कितना आ जाएगा 216। ठीक है, आया समझ में। तो ये सारे हमें जो नंबर्स मिले हैं 1 8 27 64 125 एंड 216, इन्हें हम क्या बोलेंगे, इन्हें हम क्यूब्स बोलेंगे या फिर परफेक्ट क्यूब्स भी बोल सकते हैं। आया समझ में, बस इतना आपको ध्यान में रखना है। ठीक है, चलिए नेक्स्ट क्या है, नेक्स्ट हमें दे के रखे हुए विराहांका नंबर्स। ठीक है, तो इनका सीक्वेंस क्या है 1 2 3 5 8 13 एंड 21। तो ये कैसे आते हैं ये भी हम समझेंगे। सबसे पहले आप इतना नोट डाउन कर लीजिए, कर लिया आपने नोट डाउन। तो ये सीक्वेंस कैसे आता है, ये सीक्वेंस आता है जब हम प्रीवियस 2 नंबर को ऐड कर देते हैं। जैसे कि हमें देके रखा है 1 एंड 2, तो सबसे पहले 1 और 2 तो है ही, लेकिन जब हम 1 और 2 प्लस कर देंगे तो नेक्स्ट सीक्वेंस, नेक्स्ट नंबर आ जाएगा सीक्वेंस का 3। ऐसे ही हम अगर 2 + 3 कर देते हैं, प्रीवियस 2 नंबर को ऐड कर देते हैं, तो नेक्स्ट नंबर आ जाएगा 5। ऐसे ही हम जब 3 एंड 5 कर देंगे ऐड, तो नेक्स्ट नंबर क्या आ जाएगा 8। ऐसे ही जब हम 5 + 8 कर देंगे तो नेक्स्ट नंबर आ जाएगा 13। ऐसे ही जब हम 8 + 5 तो कर दिया, 13 + 8 करते हैं, 8 + 13 करते हैं, नेक्स्ट प्रीवियस नंबर को ऐड करते हैं, लास्ट 2 प्रीवियस नंबर को हम ऐड करते हैं, तो आंसर क्या आ जाएगा 21। ठीक है, तो ये जो सीक्वेंस हमें मिल रहा है 3 5 8 13 21, जो कि प्रीवियस 2 नंबर्स को ऐड करके मिल रहा है, उन नंबर्स को हम क्या बोलते हैं विराहांका नंबर्स। ठीक है, आया समझ में। चलिए नेक्स्ट क्या है 1